want to introduce now from RealManage, Jonathan Louis. Jonathan, and he also, by the way, has the highest designation you can have for a community association manager. See that P after his name? That's what that's all about. Jonathan, say hi to everybody.
Thank you, Jeff. Much appreciated. Hello, everyone. Welcome to today's board certification webinar. I'm Jonathan Louis, National President, Business Development for the RealManage family of brands. I actually started my journey with them when I sold my management company of 15 years to them in October of 2019. Those of you that may not be familiar with us, the RealManage family of brands is a leading community management company dedicated to providing exceptional service and solutions to homeowner associations, condominiums, and other community types across the nation. We're the third largest currently, and we operate in 20 states. At RealManage, we believe in building strong partnerships with our communities, collaborating with our boards and residents to understand the unique needs and tailor our services accordingly. And basically, our slogan is to run your association like a business so that you can act like a neighbor. Now let's dive into today's topic, and I'm going to pass it over to Jeff, who's going to introduce our trainers today.
Thank you. I want to now introduce from our Palm Beach Gardens office location, one of the very few board certified specialists in condominium and plan development law, attorney Danielle Brennan. Danielle, take it away.
Thank you very much. Yes. So, like Jeff was saying, I am a board certified specialist in condominium and plan development and law. I'm actually one of 9 board certified specialists here at K. Bender Rembaum. 8 of us being board certified in condominium and plan development law, and one of us having a certification in construction law. I am located in our Palm Beach Gardens office, but we do have plenty of other office locations throughout Florida. We have an office in Pompano Beach. We have an office in Tampa, an office in Winter Springs that's in Central Florida area, and do have offices available in Miami-Dade by appointment. We are exclusively servicing community associations throughout the state of Florida. This is our bread and butter. We do this every single day, and we are particularly qualified to provide expert legal counsel to condominium associations in addition to homeowners associations and cooperatives. Just a little bit of additional housekeeping regarding the presentation. Yes, we are required by Florida law to have certain topics in our presentation. Although certain topics may not apply to every single condominium who is or board member who is attending today. And it is required to be 4 hours long. So I'm not sure if we're going to have a break built in here, but typically there will be a break after my portion, and Andrew Black, who will be coming on to the presentation after me to finish up the second half. He is also a board certified specialist in condominium and plan development law, and he is out of our Pompano Beach office. The information you're receiving here today is just that. It's for informational purposes. It's for educational purposes. It is not legal advice. If you need legal advice, we go to your association's attorney if you need an association attorney, or if you're dissatisfied with the current services provided by your attorney, we are more than happy to provide some legal representation to your condominium association. You will be able to receive a copy of the presentation. I'm not sure if that is going to be on a link after the fact, or if it's going to pop up in the chat toward the end.
Yeah, when we Danielle, to interject real quick, when we place the evaluation link a little bit later, for those of you just joining us, hit the chat button just so it appears at the bottom. It'll say chat is disabled, but that just means you can't chat to us. We can send stuff your way. That's where we'll place the link later for the evaluation. You must fill that in. Then we'll be able to send you a certificate within a few days, and you'll also have a link, as Danielle just mentioned, to download the slides.
Okay, so you don't have to take copious notes. You will get a copy of the presentation once you've filled in your evaluation. What else? there is a lot of information in the presentation, and you can always go back to that PowerPoint if you need some additional information. And our contact information is also going to be provided as well. So if you have any additional questions, feel free to reach out. So let's go ahead and get started. I'm going to do my share screen right now, and hopefully it works properly.
Looking good. It looks like it's about to share. You just got to do the swap we talked about or start the show. And folks, as Danielle's getting that ready, again, you do not need to enter into the Q&A. Am I here? Can you see this? If you're able to send a Q&A, that means you are here. Danielle, back to you, my friend.
All righty. So as I said, you will get a copy of this, and it does have all of our contact information in there as well. And let's get started. So the presentation, if you've come to a condominium board certification course with us prior to the changes in the law as of July 1st, it looks a lot different now. Like I said before, the Florida statutes require that we have certain topics, and we've organized all the information into those required topics. So I'll be handling topic 1 and topic 2. And then Andy will come on and do topics 3 and 4. About the milestone inspection and structural integrity reserve studies, I do realize that many associations may or may not have 3 or more stories. This particular portion of the presentation is going to be applicable to those condominiums that have 3 or more stories. So apologies to those that don't. So as you may know, the tragedy that happened at Champlain Towers South in 2021, where the building collapsed. After that happened, the Florida legislature determined that there was a need for some statewide structural inspection programs for aging condominiums and cooperative buildings to ensure their continued structural integrity and its safety. One of the things that was implemented was the milestone inspection requirement. So what is a milestone inspection? Well, it's a structural inspection of the building, including an inspection of the load-bearing elements, the primary structural members, which are structural elements designed to provide support for the overall load of the building, and the primary structural systems, which is just a compilation of those primary structural members. What does that mean exactly? That means that it's an inspection of your foundation, your masonry, load-bearing walls, your floor and roof systems, steel framing systems, concrete framing systems, windows, doors, wood framing, and your building facade. Now, the inspection is performed by either an architect or engineer, or a team of professionals that's led by an architect or an engineer. And the purpose of the milestone inspection is to attest to the life safety and adequacy of the building's structural components, and to determine the building's general structural condition as it affects the building's safety, and determining whether there's any necessary maintenance, repair, or replacement of any structural component needed. The milestone inspection certainly is not to determine if the building is in compliance with the Florida Building Code or the Fire Safety Code. As we know, codes change over time, and you don't need to necessarily come into compliance with existing code if you aren't touching anything concerning your building. So the inspection in and of itself is not to say that, yes, your building is in accordance with current code. It's merely to do with the structural condition of your building. Now, do you need a milestone inspection? You don't necessarily need to ask yourself that question, because the local building authority will provide you with notice of that requirement. However, as I mentioned prior to opening up this particular topic, This is going to be applicable for condominium buildings having 3 or more stories and that are either in whole or in part residential. So you might be asking yourself, okay, how would we have any non-residential portion of a condominium? Well, condominiums come in a lot of different forms. Sometimes we can have vertical subdivisions where maybe a particular floor is commercial with a built-in residential with maybe a hotel on top. In those instances, because there is that residential component and the building is more than 3 stories in height, that particular building would need a milestone inspection. Now, buildings that are purely commercial, they would not be required to have a milestone inspection. And single family, 2 family, 3 family, or 4 family dwellings with 3 or fewer habitable stories above ground are not subject to the milestone inspection requirements. Here on this particular slide, the 4 family is underlined because that's a new addition to the exceptions under the milestone inspection requirements. So for our mixed use and condominium hotels, you have to have the milestone inspection arranged by the residential condominium association and any owner of any portion of the building, which may not be subject to that condominium form of ownership. They're each responsible for ensuring compliance with the requirements of the milestone inspection, and each pays their own part for their portion of the building. When do you need a milestone inspection? Now we know that we need one. When do we need it? So the initial milestone inspection has to be performed by December 31st of the year in which the building reaches 30 years of age. And that clock starts to tick essentially on the date of the certificate of occupancy. Once that certificate of occupancy has been issued, then that marks the first day of the next 30 years within which at that point you would need to do the milestone inspection. If your building reached 30 years of age before July 1st of 2024, your initial milestone inspection has to be performed before December 31st of 2024. So you are really, really under the gun and in crunch time right now. If your building reached 30 years of age after July 1st of 2022, but before December 31st of 2024, you do have an extra year. However, you do want to be getting your experts in line, excuse me, because there are only so many architects and engineers to go around. Once you have that initial milestone inspection, you have to do another milestone inspection every 10 years from the date of the previous milestone inspection. So the local enforcement agency, which is usually your local building department, building division, whatever it's called, they can require that first milestone inspection be performed by December 31st of the year in which your building reaches 25 years of age instead of the 30 years, if there are local circumstances that would require that accelerated date. For example, proximity to saltwater. If your condominium building is on the ocean, that salt water is more corrosive and can have a greater impact and deterioration on your building. And therefore, your local enforcement agency, your building department can require that initial milestone inspection be performed ahead of time. The local enforcement agency can extend the due date for the initial milestone inspection if there's a good cause shown and the owner of the building or the association in this case have entered into a contract with an architect or an engineer to perform that milestone inspection, and there's some good cause for the milestone inspection being delayed. Now, for milestone inspection reports that are prepared before July 1st of 2022, those may be accepted by the local enforcement agency if the inspection and report substantially complies with the milestone inspection requirements. Regardless of when that inspection was completed, you still have to comply with the notice requirement, which we will talk about momentarily. You still have to comply with that notice requirement in providing them with the copy of the inspection report. If there's a previous inspection report, if the previous inspection report is accepted by your local enforcement agency, then that previous inspection is deemed your milestone inspection, and the deadline for then doing your next milestone inspection within the 10 years is based on the date of the accepted previous inspection. So once it's determined by the local enforcement agency, like I said, the building division or department, that you need a milestone inspection, they have to provide you with written notice of the need to do that inspection. Then once the association receives that notice, the association has to notify the unit owners within 14 days after receipt of the building department's notice that a milestone inspection is required. And that notice has to provide the date that the milestone inspection must be completed. Now, the milestone inspection consists of 2 phases. We have your phase 1, which is a visual examination, and phase 2, which is destructive or could be non-destructive testing. It's a more invasive inspection of the building. Delving into the phase 1 milestone inspection, in this particular phase, the architect or the engineer performs a visual examination of the habitable and non-habitable areas of the building, including the major structural components, and provides a qualitative assessment of the structural conditions of the building. Now, the architect or the engineer who performs that milestone inspection, that phase 1 milestone inspection, has to prepare and submit an inspection report. And there are particular forms that are required for that inspection report that are promulgated by the Florida Building Commission. A phase 1 inspection has to be completed within 180 days after the association receives written notice from the local enforcement agency. Completion of the phase 1 milestone inspection means that that engineer or the architect who performed the inspection submits the inspection report by email, by mail, or commercial delivery service to the local enforcement agency. And again, you do need to have that form completed, and there's a form particular for the phase 1, and there is a form particular for phase 2. And the engineer or the architect who is completing your milestone inspection should be very aware of what those forms are. If the architect or the engineer finds no signs of substantial structural deterioration to the building components, then there's no need to do a phase 2 inspection. However, if there are signs of substantial structural deterioration, then you would be required to do a phase 2 inspection. So what does substantial structural deterioration mean? Substantial structural distress or substantial structural weakness that negatively affects a building's general structural condition and integrity. Now, typically speaking, surface imperfections like cracks, distortion, misalignment, signs of leakage, peeling of finishes, those would not be in and of themselves indicative of a substantial structural deterioration, but it could be if it's more than just merely surface imperfections. In the phase 2 milestone inspection, the engineer or the architect will determine whether or not destructive or non-destructive testing is required. And the inspection is as extensive or as limited as necessary to fully assess whatever areas of structural distress there are to confirm that the building is structurally sound and safe for residential use, and to recommend a program for fully assessing and repairing distressed and damaged portions of the building. Because remember, not only is this the milestone inspection to determine, okay, this is the condition of the building, but it's also to provide recommendations of the maintenance, repair, or replacement of those structural components of the building. If that phase 2 inspection is required, then within 180 days after submitting that phase 1 inspection report, the architect or the engineer who did the phase 2 inspection has to submit a phase 2 progress report to the local enforcement agency with a timeline for the completion of that phase 2 inspection. The inspector who completes the phase 2 milestone inspection has to prepare and submit an inspection report. And again, there is a phase 2 milestone inspection form that's promulgated by the Florida Building Commission that has to be submitted as well. Now, once either the phase 1 or the phase 2 milestone inspections are completed, the architect or the engineer who performed that inspection, they have to submit a sealed copy of the inspection report with a separate summary of, at a minimum, the material findings and recommendations in that inspection report to the condominium association, the owner of any other portion of the building, which is not a condominium. Again, in that vertical subdivision, maybe it's the hotel owner, maybe it's the owner of the commercial property, and the building official of local government, which has jurisdiction. So your local building department. The inspection report has to minimally have all the following criteria: bearing the seal and signature of the engineer or architect, indicate the manner and type of inspection, identify any substantial structural deterioration, state whether there are unsafe or dangerous conditions observed at the building, to recommend any remedial or preventative repairs, and to identify and describe any items requiring further inspection. So now we have our milestone inspection association. What are we supposed to do with it now? So within 45 days after receiving the applicable inspection report, the association has to distribute a copy of the inspector prepared summary of the inspection report to each unit owner, regardless of the findings, whether it's good or bad, doesn't matter. You do have to provide a copy, either by mail or personal delivery to the owner's mailing address or to the email address if the owner has consented to receive notice by electronic transmission. The association must also post a copy of the inspector prepared summary in a conspicuous place on the property and publish the full report and the inspector prepared summary on the association's website if the association is required to have a website. And we will talk about those website requirements in the next section. Local government has the ability to adopt ordinances requiring that repairs for substantial structural deterioration be scheduled or commenced within particular timeframes. However, the repairs have to be commenced no later than 365 days after receiving that report. If the owner of the building fails to submit the report, if the owner of the building fails to submit proof that repairs have been scheduled, or have commenced for substantial structural deterioration identified in a phase 2 inspection report within that required time frame, then local government must review and determine if the building is unsafe for human occupancy. Now, after that, after all required repairs have been completed, the original milestone inspector must re-inspect the areas noted in the original report, provide an amended report with a signed and sealed letter stating that all necessary repairs and corrections have been completed, and confirm that the building is acceptable for continued use under the present occupancy of that building. And the building owner, here the association, or the responsible inspector must submit the letter to the building official. So they need to receive confirmation that all of those repairs have been completed. One thing I also wanted to mention regarding the phase 1 inspection is that pursuant to the Florida Building Code, Chapter 18 of it, which was recently adopted to address the milestone inspection requirements, the building official has to be notified if there was unpermitted work discovered in the structural components. So that's something that isn't necessarily covered by a Florida statute, but that is provided in the building code. If there was unpermitted work done and it is observed by the inspector, or the architect, or the engineer who's performing the phase 1 inspection, the building official has to be notified. What happens if the association fails to obtain that milestone inspection? Well, if the officers or directors of the association willfully and knowingly fail to have a milestone inspection performed, such failure is deemed a breach of their fiduciary duty. In the event of a breach of fiduciary duty, you guys may have some personal liability there, so you need to be very mindful of your milestone inspection requirements. A local enforcement agency can have timelines and penalties with respect to compliance with the milestone inspection requirements. So you want to be sure that you're not only checking, complying with the requirements pursuant to Florida statutes, but also in accordance with whatever local ordinances may be applicable. And that's something that the architect or engineer who is doing your inspection should be able to provide you with guidance on. Now, the Florida Building Commission was required to, or is required to adopt rules establishing a building safety program for implementing the milestone inspection requirements. The deadline for doing so was December 31st of 2024, but they did it back in August, creating that Chapter 18 in the Florida Building Code. And the building inspection program does provide for standardized inspection and reporting forms. Again, that's that phase 1 form. There's a phase 2 form, and does have some additional requirements concerning how that inspection is to be conducted. So turning to structural integrity reserve studies and mandatory reserves. What is a structural integrity reserve study? Sometimes you may hear it referred to as a CEUs or CEUs, and that's simply because of the Structural Integrity Reserve Study acronym there. So I usually say CEUs. A lot of people say CEUs, but CEUs to me just makes more sense.
Sears is a retailer that went out of business. Right?
Yeah, and I hear it all the time. I'm like, that SIRS does not sound like Sears to me. SIRS. Anyway, so it's a study of reserve funds that are going to be required for future major repairs and replacements of, and these are at a minimum, these building items which relate to structural integrity and safety. So the roof, the structure, which is your load-bearing walls, your primary structural members, primary structural systems. That should sound familiar to you based on the milestone inspection terms that we just went over. Fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows and exterior doors, which are maintained by the association, and any item that has a deferred maintenance expense or replacement cost that exceeds the $10,000 and where the failure to do so would result in a structural issue with your building. So do we need a structural integrity reserve study? A residential condominium association has to have a structural integrity reserve study completed at least every 10 years after the condominium's creation for each building on the condominium property that is 3 stories or higher in height. Again, this doesn't apply to all condominiums in Florida, but it does apply to those that are 3 stories or higher and are residential. Also does not apply to single family, 2-family, or 3-family dwellings with 3 or fewer habitable stories above ground. Any portion of a building that has not been submitted to the condominium form of ownership, or any portion of a building that's maintained by another party other than the association. For example, something that's maintained by the unit owner would not be included within the structural integrity reserve study. And commercial condominiums are not subject to the CEUs requirements. So the structural integrity reserve study, there are really 2 components of it. One is the visual inspection of the condominium property, and then the second part is going to be the financial portion of it in determining what the reserves are. At a minimum, a structural integrity reserve study must identify each item of the condominium property that's being visually inspected, state the estimated remaining useful life and the estimated replacement cost or deferred maintenance expense of that particular item, and provide a reserve funding schedule with recommended annual reserve amounts to achieve that estimated replacement cost at the end of the estimated remaining useful life of an item. So for example, the roof, let's say in a completely hypothetical world, because this would never ever happen, let's just say a roof replacement costs $100,000 for your condominium building and has a useful life of 10 years. That would mean that every year you would be funding $10,000 to have that $100,000 at the end of that 10-year period. So who can perform your CEUs? For the visual inspection portion, it has to be an engineer or an architect, or someone who has certification as a reserve specialist or professional reserve analyst. And then the financial part of it can be performed by anyone who has qualifications to perform that financial portion of the structural integrity reserve study. So associations that were existing on or before July 1st of 2022, which are unit owner controlled, meaning it's not developer controlled, they have to have a structural integrity reserve study completed by December 31st of 2024. Again, you're in major crunch time if you have not done your CEUs already. And it's for each building, again, on the condominium property that's 3 stories or higher in height. However, if your association is required to complete a milestone inspection on or before December 31st of 2026, you can complete the structural integrity reserve study at the same time as doing the milestone inspection, but in no event can your structural integrity reserve study be completed after December 31st of 2026. If your milestone inspection is required or an inspection completed for a similar local requirement, which may be like a 40-year recertification type of requirement, if that was performed within the past 5 years and meets the structural integrity reserve study requirements, then that inspection can be used in place of the visual inspection portion of the structural integrity reserve study. However, you're still going to have to address the financial portion of it because neither the milestone inspection or, like, for example, a 40-year recertification requirement would provide for those projected costs over a remaining useful life in order for you to properly budget for reserves. So we've done our CEUs. We have our CEUs in hand. Now what do we do with it? So this is something that new that was done in this last legislative session. Within 45 days after receiving that structural integrity reserve study, the association has to provide a copy to each owner or deliver to each owner a notice that the completed study is available for inspection and copying upon request. When providing a copy or the notice, it has to be sent by U.S. mail, personal delivery to the address provided by the owner for fulfilling the association's notice requirements. Or again, you can send it via email for owners who have consented to receive notice by electronic transmission. The association must also provide the division with a statement indicating that the study was completed and that the association provided or made available the study to each unit owner in accordance with the requirement that was just discussed. The statement has to be provided to the division in the manner established by the division, and you could go to the Division of Florida Condominiums, Timeshares, and Mobile Homes website, and they do have additional information of how you can submit your CEUs to the division. Now, the division ultimately is going to compile a database and put together a list of those condominiums that have completed their CEUs in its annual report that's going to be due December 31st of this year. And we'll have that database available by January 1st of 2025. And there's going to be a link to the DBPR's database on its webpage by January 1st of 2025.
I'm going to place a link to that section of the DBPR website in the chat right now, which is also going to serve as a great test, folks, to make sure that you properly clicked on the chat button so it shows up. Back to you.
All right, thanks, Jeff.
All right.
That structural integrity reserve study has to be maintained for at least 15 years after the study is completed. And if the association is required to have a website, again, we will talk about the website requirement shortly. The structural integrity reserve studies have to be posted on the association's website or app, because there is the option to have a downloadable mobile app for your association. If the officers or directors of an association willfully and knowingly fail to complete the structural integrity reserve study, such failure is a breach of their fiduciary duty. So just like the milestone inspection report, you need to make sure that you're on top of these requirements. If the association is required to have a CEUs, then the reserves have to be maintained for the structural integrity reserve items for which the association is responsible. Reminder, that's your roof, the structure, the windows, if windows are maintained by the association, waterproofing, painting, all of those systems which affect the structural integrity and safety of the building. The reserve amount for each of those items has to be based on the findings and recommendations of that most recent CEUs. And the association can adjust those replacement reserve assessments annually to account for inflation or any changes in estimates of, the costs to replace or to provide that deferred maintenance or the useful life of a particular asset. Now, there are certain components that may not have an ascertainable life or have a life greater than 25 years. For example, the foundation. With respect to those items, the association is not required to reserve replacement costs. However, the association has to reserve the amount of deferred maintenance expense, if any, which is recommended by the Structural Integrity Reserve Study for that particular item. Now, as we know with our traditional reserves, which have been required for condominium associations for, as long as I can recall, you can waive and reduce reserves for those non-CEUs items. Now, it's been clarified that waiving or reducing the reserves is by a majority vote of the total voting interest of the association, of a unit or controlled association, to vote to approve to either reduce those reserves or to completely waive those non-CEUs reserves. Now, for CEUs reserves, you do have the ability to waive or reduce reserves only if your budget is adopted before December 31st of this year. If your budget is adopted on or after December 31st of this year, you cannot have a membership vote to waive or reduce the CEUs reserves. So I know a lot of associations may be facing some very large assessments due to having to reserve for the CEUs, the structural integrity reserve study items. If you're able to adopt your budget prior to December 31st, you have the option to reduce reserves to, in effect, phase in the need to fully fund your CEUs reserves. Now, for the multi-condominiums, there are different funding methods that can be approved by the division, but this really only applies to multi-condominium associations having at least 25 condominiums within their jurisdiction. Reserve funds and any interests that accrue on those reserve funds have to remain in those reserve accounts. and can only be used for authorized reserve expenditures unless they are used for other purposes as approved in advance by a majority of the total voting interests of the association. However, for a budget that's adopted on or after December 31st, again, those CEUs reserves become sacrosanct. You cannot touch them for any other purpose than those structural integrity reserve items. Now, pooling. So a lot of associations maintain pooled accounts because pooling allows for an overall lesser funding requirement because you're pulling out money from this pool at different periods. So a lot of associations do prefer to do the pooling method. Pooling in and of itself is not specifically addressed by Chapter 718, which is our Condominium Act. However, generally speaking, pooling reserves is essentially using reserve funds for other reserve items and can be done upon the membership's approval by a majority of the total voting interests. Certainly, you cannot pool traditional reserves with your CEUs reserves. So CEUs reserves, again, they're sacrosanct. You can't have them in the same pool as your other reserves. Now, whether or not you can pool structural integrity reserve study items, you really need to check with your legal counsel, because again, this is not addressed. Pooling is not addressed by the Florida statutes. So if the local building official determines that the entire condominium building is uninhabitable due to a natural emergency like a hurricane, like an earthquake, then the board, upon approval of a majority of its members, can pause contributions to its reserves or reduce reserve funding until that local building official determines that the building is habitable, essentially allowing the association to use its funds to make the building habitable without the need to reserve. Any reserve account funds held by the association can be expended pursuant to the board's determination to make that condominium building habitable. And upon determination by the local building official that the building is habitable, the association then has to begin making contributions to its reserves. So milestone inspections and CEUs, what else? This is kind of like a compilation of other information that's required and related to structural integrity reserve studies and milestone inspections, but not necessarily within like nice and tidy categories that we were discussing before. So the developer requirements here for providing the structural integrity reserve study doesn't matter when the certificate of occupancy was issued or the height of the building. The developer has to include with its turnover inspection report a structural integrity reserve study attesting to the required maintenance, condition, useful life, and replacement costs of the roof, the structure, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, and windows and exterior doors. Note that it doesn't necessarily have that. It doesn't have that other catch-all provision for any asset that has a replacement cost, deferred maintenance cost of $10,000 or more, which would affect the structure of the property. That's something that's only provided for in the general CEUs reserves requirement. But for developers, they don't have to provide that in their CEUs portion of the turnover inspection report. Unit owner disclosures to prospective purchasers. Yes, unit owners are going to be required to disclose the milestone inspection report and structural integrity reserve study to their purchasers. Each contract for the sale of a residential unit entered into after December 31st of this year has to contain inconspicuous type, certain disclosures regarding the milestone inspection or structural integrity reserve study. And the contract that does not have these disclosures is voidable at the option of the purchaser before closing. If an association is not required to have a milestone inspection or a structural integrity reserve study, then each contract for the sale of a residential unit entered into after December 31st of this year has to contain inconspicuous type of statement indicating that the association is not required to have a milestone inspection or a structural integrity reserve study, whichever is applicable. If the association is required to perform a milestone inspection or a structural integrity reserve study and has not completed it, then each contract for the sale of a residential unit entered into after December 31st of this year has to contain inconspicuous type of statement indicating that the association is required to have these things but has not completed them. And if the association has completed them, then each contract for the sale of a residential unit entered into after December 31st of this year has to contain a conspicuous type, the disclosures that are required pursuant to this statute. And it does have the actual text in the statute itself. Each prospective purchaser who has entered into a contract for a condominium unit is entitled at the seller's expense to a current copy of, in relevant part, the inspector prepared summary of that milestone inspection report and the association's most recent structural integrity reserve study. And once these reports have been provided, the buyer then has a 3 business day right to cancel the contract upon written notice to the seller. And that right to void the contract cannot be waived. Now, for our condominium associations, there are certain alternative dispute resolution provisions in section 718.1255 of the Florida statutes. As of July 1st, 2027, the definition of the term dispute, which would be subject to alternative dispute resolution procedures, will be expanded to include the failure to obtain the milestone inspection report, failure to obtain the structural integrity reserve study, failure to fund reserves as required for a SIRS study item, or the failure to make or provide necessary maintenance or repairs of the property recommended by a milestone inspection or a structural integrity reserve study. Now, although under these alternative dispute resolution statutes, there is the option to do mandatory pre-suit mediation or mandatory non-binding arbitration, these particular disputes will not be subject to the mandatory non-binding arbitration option, but rather have to be submitted to pre-suit mediation. And if unresolved at mediation, then the parties can go to litigation. Now, delving into our next topic, which includes elections and official records and record keeping. For our elections, when do we need an election? Well, you have an election when there's an expiration, there's a vacancy on the board caused by the expiration of a director's term. You would certainly have your election. There are other ways in which you can have an election. If there's a vacancy occurring on the board before the expiration of a term, except by recall, there is an exception for recall, then that vacancy is usually filled by the remaining board members, or the board can opt to hold an election to fill that vacancy. Our election timeline, 60, 40, 35, 14. Those are basic time periods. Not less than 60 days before the election, the association has to provide each unit owner with a first notice of the date of the election. Then anybody who's eligible to be a candidate for the board can give written notice to the association of their intention to run for the board at least 40 days before that scheduled election. Those candidates can provide a candidate information sheet to the association at least 35 days before the election. That candidate information sheet would then get sent to the members with the second notice of the annual meeting and election, which has to be provided to the owners not less than 14 days before that annual meeting. Now, the candidate information sheet, that's simply a one-page, 8.5 by 11 sheet that says, you know, it could be a resume or a summary, essay prepared by the candidate to say, this is why I think you should elect me to the board. And a copy of that is made by the association and sent to each owner. The association is not going to be liable or responsible for the information provided in any candidate information sheet that gets sent to the members. So and it's certainly not required. This is at the option of the candidate. Now, because that the candidates have the ability to provide that candidate information sheet 35 days before the annual meeting and election, that second notice can't be sent greater than 34 days before the annual meeting and election, just to provide the candidates with the ample time to provide a candidate information sheet. Now, that second notice can be mailed, delivered, electronically transmitted to the owners. Although electronic transmission may be an option for providing that second notice, at least to those owners who have provided written consent to receive notice by electronic transmission, because of the double envelope balloting system, which we'll talk about, go into more detail about, it's not really recommended that you use electronic transmission as that means of providing that second notice, because you need to provide those envelopes as well. Together with that second notice of the annual meeting, in addition to providing the envelopes, in addition to providing the candidate information sheets, you will also provide a ballot which lists all of the eligible candidates alphabetically by their last name. Now, unless the governing documents provide otherwise, a board consists of 5 members. Unless that condominium has 5 or fewer units, then the board can consist of at least 3 members. Typically, the directors serve 1-year terms unless your articles of incorporation or the bylaws allow the directors to serve terms longer than a year. This particular restriction does not apply to a timeshare or non-residential condominium, or if your documents provide for a staggered term. Sometimes you may have your 5 members serving a 2-year staggered term, meaning that in 1 year you're electing 3, the next year you're electing 2, so on and so forth. Term limits. So a director cannot serve more than 8 consecutive years. That's years, it's not terms. If you have a 2-year staggered term, we're talking years here and not terms. But however, there are exceptions to this. First off is the only board service that counts towards this term limitation are those years of service occurring on or after July 1st of 2018. Okay, so we're starting our count of years at July 1st of 2018. And even if someone has served more than 8 consecutive years, if it's approved by 2/3 of the votes cast in the election that person should continue to serve, well, they still can. Also, if there are not enough eligible candidates to fill vacancies on the board and that person is willing to serve, well, then they can also serve on the board in that instance as well. In a residential condominium association of more than 10 units, co-owners of a unit cannot serve as directors at the same time unless they own more than 1 unit or unless there are not enough eligible candidates to fill vacancies on the board. Mind you, this is serve as directors. Doesn't mean they can't run against each other and one be elected, whereas the other is not. So this doesn't necessarily have to do with their candidacy so much as what happens after the election. If the number of vacancies equals or exceed the number of candidates, then there's no election required. Makes sense, right? We're not going to be voting for people to be on the board wherein there aren't a number of candidates to select from for all the vacancies to be filled. That's otherwise referred to as an election by acclamation. You wouldn't have any balloting. You would just have an announcement at the annual meeting of who the directors are, elected by acclamation. For an election, there is no quorum requirement. However, at least 20% of the eligible voters have to cast a ballot in order to have that valid election. Now, if there's other business being conducted at the annual meeting, let's say that the members are going to be voting on an amendment. Well, in that case, you would need a quorum present in person or by proxy in order to conduct that vote. But for just doing the election, you don't need a quorum. You just need 20% of the eligible voters to cast a ballot in the election. Now, elections are decided by a plurality of the ballots cast. So if I'm a unit owner having one vote and there are 3 vacancies, I can vote for up to 3 people on my ballot. And then whoever receives the most votes would be elected to the board. Now, the ballots, sign-in sheets, voting proxies, and any other papers that relate to voting by the owners have to be maintained for a period of 1 year from the date of that vote. Or if it's an election, the next election, if it's later than 1 year. For example, like your staggered terms. Any challenge to the election process has to be commenced within 60 days after the election results are announced. If there's an issue regarding the election after those 60 days, well, then you would be instituting a recall. And recalls in and of themselves cannot be brought if there's less than 60 days to the next election, right? Because you're not going to be able to, do the recall before it becomes like a moot issue once the election takes place. So a candidate is an eligible person who has timely submitted written notice of their intent to become a candidate. Remember, timely notice is that at least 40 days before the annual meeting. Again, this particular bullet point is reiterating that they have to provide written notice of their intent to be a candidate and to run for the board at least 40 days before the annual meeting in order to have their name on the ballot. A person who's delinquent in the payment of any assessment due to the association as of the deadline to submit that notice of intent to be a candidate is not eligible to run for the board. And a person who's been suspended or removed by the division under the Condominium Act, again, the Condominium Act is Chapter 718 of the Florida statutes, is not eligible to be a candidate. A person who's been convicted of a felony or has been convicted of any offense in another state, which would be considered a felony here in Florida, is not eligible for board membership unless their civil rights, which would include the right to vote, to hold public office, to serve on a jury, have been restored for at least 5 years as of the date that person seeks election to the board. Now, if it's later determined that a person was not eligible for board membership due to a prior conviction, that discovery doesn't invalidate any of the actions taken by the board while that person was on the board. If a criminal charge is pending against an officer or director, for example, forgery of a ballot, theft or embezzlement of association funds, that person cannot be appointed or elected to a position as an officer or director of any association, not just the one that they're in, but any association. And that person cannot have access to the official records of any association unless there's a court order. As I mentioned before, voting in the election is by double envelope secret ballot system. You cannot vote in an election by proxy, whether it's limited or general. You have that ballot that has all of the candidates' names in alphabetical order by last name. You complete your ballot, you fold it up, you put it into an inner envelope. Usually it's just a blank envelope that says in big bold letters on it, ballot. You seal that envelope, you put it into a bigger outer envelope. Now, the outer envelope has to have the name of the person who's voting, what unit or units are being voted, and have a space for that person to then sign their name. Each inner envelope can only have one ballot. If you own more than one unit, and you're able to vote, you're then eligible to cast more than one ballot. Each of your ballots has to have a separate inner envelope, but you can include it within the same outer envelope. You'll just have to make sure that on the outside of the envelope, you are notating the multiple unit numbers that are being voted in that single outer envelope. The voter has to sign the outside of that envelope in the space provided, and then either mail or hand deliver their ballot envelopes to the association. Once that ballot has been received, the owner cannot rescind the ballot or change their ballot. A unit owner cannot authorize any other person to vote his or her ballot, and any ballots improperly cast or invalid. An owner who violates this provision can be fined by the association. And if a unit owner needs assistance in casting a ballot, they can obtain that assistance, for example, if they're blind or they have a disability, or they do not know how to read or write. Now, for the information on the outside of the outer envelope, the association can verify that outer envelope information prior to the annual meeting and election. The verification is done by an impartial committee consisting of members who are not current board members, officers, candidates for the board, or any of their spouses. That particular committee meeting has to be open to all members, noticed like a board meeting, for example, that 48-hour notice conspicuously posted on the condominium property, and held on the same day as the election. When they're verifying the information, the signature and the unit identification on that outer envelope is checked against the list of qualified voters, and then they are marked off as having voted. Any outer envelope that's not signed by an eligible voter is marked disregarded or with words of similar import, and any ballots that are in that outer envelope are not counted. A person who engages in a fraudulent voting activity related to an election, like using threats, bribery, or intimidation related to voting or casting a ballot, commits a first-degree misdemeanor. Forgery of a ballot envelope or voting certificate used in a condominium association election is punishable as a third-degree felony. You will notice that there are now a whole host of different criminal penalties put in place in the Condominium Act. For electronic voting, this has been a great tool for many associations. An association can use an online voting system for all owner votes, including the election, if an owner consents electronically or in writing to online voting, and that consent is valid until the owner opts out of online voting. Now, if someone votes by way of the online voting system, they're counted as being present for the purposes of determining a quorum. In order to make online voting available to your members, the board has to adopt a particular resolution, and the board meeting to adopt that resolution has to be noticed at least 14 days before the meeting by mail, hand delivery, or electronic transmission, again, only to those who have consented to receive notice by electronic transmission, and also posting the notice on the condominium property. And that particular notice has to be evidenced by an affidavit. So this particular resolution has to provide that owners will receive notice of the opportunity to vote through an online voting system, has to establish regional procedures and deadlines for owners to provide their written consent, opting into it, and their written opt-out of the voting, online voting procedures. Now, once that has been established, online voting has been established, the association has to provide each owner with the ability to authenticate their identity, ensure the secrecy and integrity of the election ballots, and a way to confirm at least 14 days before the voting deadline that their device can communicate with the online voting system. Now, that online voting system has to be able to authenticate the owner's identity, authenticate the validity of each electronic vote, transmit a receipt, permanently separate any authentication or identifying information from that electronic ballot, and store and keep electronic votes accessible to election officials for recount, inspection, and review purposes. There are plenty of different services out there now that comply with these requirements, and they can certainly provide you with additional information and assistance in obtaining membership opt-ins and things like that. If the board authorizes online voting, the first notice of the date of the election has to disclose the procedure and deadline to consent to electronic voting. So that first notice, which you're sending at least 60 days prior to the annual meeting and election, you have to provide the ability to provide consent to participate in electronic voting. If the board authorizes online voting, the board has to honor a unit owner's request to vote electronically at all subsequent elections, unless the owner opts out of online voting. And a vote of the unit owners may not be taken on any issue other than whatever issues were being voted upon on the electronic vote if a quorum is established based on unit owners voting electronically. So whatever business is being conducted, if your quorum is based on your online voters, well, the business conducted is limited to whatever votes were provided in an electronic ballot. On to our officers. Unless otherwise provided in your bylaws, the board has to have a president, secretary, and a treasurer who perform the duties customary to those offices. Unless prohibited in the bylaws, the board can appoint other officers and grant them duties as it deems appropriate, and the officers serve without compensation and at the pleasure of the board. Typically, officers are selected by the board immediately following the election of the directors at a board meeting that's otherwise referred to as the organizational meeting. Directors cannot vote by proxy or by secret ballot. However, directors can use secret ballots to vote for their officers. And there's no prohibition against changing officers midterm. Again, officers serve at the pleasure of the board, so they can be changed by the board as needed. Now, there are a lot of ways that you can be disqualified from service as an officer or a director. An officer or director who knowingly solicits, offers to accept, or accepts a kickback commits a third-degree felony and is subject to a civil penalty. Civil penalty, read here, you have to pay a fine and must be removed from office and a vacancy declared. Now, a kickback is anything or service of value that hasn't been paid for and that benefits that particular person or their immediate family, or from any person or providing or proposing to provide goods or services to the association. An officer or director who's charged by information or indictment for any crime that's outlined in this particular statute, which includes forgery of a ballot, theft or embezzlement of association funds, or obstruction of justice, is removed from office. However, if the charges are resolved without a finding of guilt, then that officer or director must be reinstated for the remainder of the term if there's any remainder. A director or an officer who is more than 90 days delinquent in the payment of any monetary obligation due to the association is deemed to have abandoned their seat on the board, creating a vacancy on the board to be filled according to law. Now, what's interesting is that you don't see maybe like, for example, a director who violates the pet prohibition is off the board or is not eligible to serve on the board. You know, we get those questions often where, you know, are they in good standing for other violations of the governing documents? But interestingly enough, it is limited to the delinquency and not necessarily to any other restrictions. A director who knowingly and willfully violates the official records inspection requirements, which we will discuss soon, 2 or more times in a 12-month period, which is their definition of repeatedly, commits a second-degree misdemeanor and must be removed from office and a vacancy declared. Any person who knowingly or intentionally defaces or destroys accounting records that are required to be maintained during the period for which such records are required to be maintained, we will talk about more the official records next, or who knowingly or intentionally fails to create or maintain accounting records that are required with the intent of causing harm to the association or one or more of its members, commits a first-degree misdemeanor, is personally subject to a civil penalty, again, it's a fine, and must be removed from office and a vacancy declared. Finally, a person who, I should say finally for this particular slide, because there are more, a person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to help someone else to do the same thing, must be removed from office and a vacancy declared.
Hey, before you get to that next slide,
Yes.
opportunity for you to have a sip of water. I just want to bring something up real quick. I'm still getting some questions in the Q&A. Hey, I'm checking in. Am I here? No need to do that. If you can see the Q&A and you can type a Q&A and you can send a Q&A, you are here. You are successfully logged in. In addition, for those who join late, we will be using the Zoom attendance sheet to verify complete attendance. At the end in the chat area, that's where we're going to place the link for the evaluation, and that's the data we use to make your certificates. Sorry, Danielle, for the interruption. Just getting a lot of that in the Q&A. Back to you.
Okay, thanks. That's okay, because you know what? We're just talking about crimes and things that can get you kicked off the board. Anyway, a person who uses a debit card issued in the name of the association or billed directly to the association for an expense that's not a lawful obligation of the association commits theft and has to be removed from office and a vacancy declared. Now, what is a lawful obligation of the association? Well, it's an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes or the written budget. If the board finds that an officer or director has violated the conflict of interest requirements, which I do believe that Andy will discuss in the second half of this presentation, the officer or director is deemed removed from office, creating a vacancy to be filled according to law. And finally, really finally, a director who fails to timely file the written certification and educational certificate, which you'll get from having attended this course today and turning in your evaluation, is suspended from service on the board until they comply with this requirement. Now, the failure to have the written certification and educational certificate on file does not affect the validity of any board action, but again, it does result in a suspension from the board. Now, condominium association website. See, I told you we were going to get to it, so here we are. What are these requirements? Condominium associations having 150 or more units must create a website for the posting of association documents to be operational on or before January 1st of 2019. So obviously you already have to have this in place. However, effective January 1st of 2026, these website requirements will apply to an association having 25 or more units. So if you fall within this area, you need to gear up to have your association website. And that means that if you don't have your official records in digital form already, you need to start getting them scanned and organized in a digital server or something somewhere. Because there are website posting requirements for these official records. So an association's website must be an independent website or web portal wholly owned and operated by the association, or you can have a third-party provider that provides you with that web portal. The association's website has to be accessible through the internet and has to have a web page, web portal, or other protected electronic location that's not accessible to the general public and only accessible to unit owners and employees of the association. Now, owners are entitled to receive a username and password so that they can access that private portion of the association's website that's going to have the notices, the records, the documents that have to be electronically provided. Now, what are these documents? It's a current copy of the recorded declaration of condominium, your bylaws, and all amendments to those documents, the articles of incorporation, which are filed with your department, the Florida Department of State Division of Corporations, or other documents creating the association and any amendments to those, the current rules of the association, a list of all executory contracts or documents to which the association is a party or has obligations, or the owners have obligations. After there's bidding for the related materials or equipment has closed for that particular contract, then a list of bids received by the association within the past year. Now, you could provide summaries of bids for materials, equipment, or services which exceed $500. Those have to be maintained on the website or the app, again, mobile downloadable app, for 1 year. In lieu of those summaries, you would provide a copy of the complete bid posted. It's the annual budget, any proposed budget to be considered at the annual meeting, the financial report, and any proposed financial report to be considered at a meeting. Your director certification needs to be posted on that website. All contracts or transactions between the association and any director, officer, corporation, firm, or association that's not an affiliated condominium association, or any other entity in which an association director is also a director and financially interested, contracts relating to and documents relating to a conflict of interest or possible conflict of interest, notice of any board meeting, the agenda, and any other document required for the meeting has to be posted no later than the date required for notice. So, for example, our board budget meeting, board budgets meetings have to be noticed at least 14 days in advance, and you have to provide the proposed annual meeting, annual budget on the website. That's what this is saying, any other document to be considered by the board. The notice of any unit owner meeting and the agenda for that meeting no later than 14 days before the meeting. Now, there are certain requirements for the posting of these notices on the website. Has to be conspicuously labeled notices. If it's going to be on a subpage, the association has to post on its website or application any document to be considered and voted on by the owners. For example, as we were talking about before, an amendment. If they're going to be voting on an amendment, you have to post the amendment as well. And those documents have to be posted at least 7 days before the meeting at which the document or the information within the document will be considered. Again, you have to post your CEUs as well as your milestone inspection reports, copies of all building permits issued for ongoing or planned construction. All of the information is going to have to be posted onto your website. So like I said, for those associations who are going to fall into the website requirements coming January 1st of 2026, you're going to want to start getting your ducks in a row from your governing documents so that you're able to comply with the website posting requirements. Now, the failure to post these documents on the website do not in and of themselves invalidate any action or decision of the association. Each association must designate on its website a person or entity with a street or email address for the receipt of a request of a estoppel certificate. And I do believe Andy will also talk about those estoppel certificate requirements in his portion of the presentation. The association must ensure that the information and records that are not accessible to unit owners are not posted on the association's website, and we will talk about what those inaccessible records are. If protected information or information restricted from being accessible to unit owners is included in documents that are required to be posted, then the association has to make sure that that information is redacted from that record before they post it on the website. However, in complying with the posting requirement, there's no liability for disclosing information that's protected or restricted unless that disclosure was made with a knowing and intentional disregard of the protected or restricted nature of such information. As I've mentioned many times, mobile application, instead of posting the required documents on a website, the association can make documents available through a downloadable mobile app. And the app must meet all other requirements imposed on a website by statute, which we discussed. Now turning to our official records, what are our official records? Providing access to the official records. So official records are comprised of plans, permits, warranties that were provided by your developer, your governing documents, including your declaration, bylaws, articles of incorporation, all amendments to those, copy of your current rules, meeting minutes, insurance policies, financial records, accounting records, a current roster of all unit owners, their mailing addresses, unit identifications, voting certifications if you have voting certificate requirements, and if known, telephone numbers. Now, the association must also maintain and make available for inspection the email addresses of those owners who either consented to receive notice of association mailings via email or expressly indicated that the email can be shared with other owners. Now, emails may only be used for the business operation of the association and cannot be sold or shared with outside parties. More on what are official records, copy of your management agreement, really any contract that the association is a party or has obligations, or the members have obligations, bills of sales, your ballots, sign-in sheets, voting proxies, any papers related to voting by the unit owners, rental records if the association is acting as agent for the rental of condominium units, your current question and answer sheet. Now, I get a lot of board members don't realize that there is a requirement to have a question and answer sheet updated annually. This is something that there's a form provided by the Division of Florida Condominiums, Timeshares, and Mobile Homes. Make sure that you have that question and answer sheet and that you are updating it. You would be surprised at how many associations don't know that that thing exists and that there is a requirement to maintain it. A copy of all inspection reports, which we talked about before, your bids, affirmative acknowledgements. Now, this is having to do with the method of delivering assessment invoices and statements, which Andy will talk about in his portion of the presentation. The board member educational certificates, and really this catch-all, all other written records not specifically included in the statute that relate to the operation of the association. So anything related to the association that's a written record, you're going to have to include it in the official records of the association. Now, how long do we have to keep these records? All official records must be maintained for at least 7 years. Mind you, it's at least. This is a minimum retention period. This is not a maximum. So it doesn't mean that, oh, okay, once 7 years are up, I can just throw the documents away. That's not the case. However, there are certain exceptions to this 7-year minimum retention period. These records have to be maintained permanently from inception of the association, being plans, permits, warranties, items provided by the developer, your recorded declaration, bylaws and amendments to those, articles of incorporation, amendments to those, copy of your current rules and all meeting minutes. Your CEUs and inspection reports have to be maintained for 15 years, as we discussed in the beginning. Bids for work to be performed for materials or for materials, equipment, or services, those have to be maintained for at least a year after receipt of the bid. And again, your ballot sign-in sheets, voting proxies, any paper or electronic records related to voting by the owners have to be maintained for at least a year from the date of the vote. Now, this is a new requirement, and this might drive some board members crazy. The official records must be maintained in an organized manner that facilitates inspection of the records by a unit owner. This is a brand new requirement. So yes, you guys are going to have to be organizing your official records to make sure that they are easily inspected by your members. If the official records are lost, destroyed, or otherwise unavailable, the obligation to maintain the official records includes a good faith obligation to obtain and recover those records as is reasonably possible. Yeah, let's see what happens with those new statutory requirements. So now that we know what constitutes our official records, what records are accessible to owners and how do they get to it? So after receipt of written requests by the board or its designee, the official records must be made available to an owner and the owner's authorized representative within 10 business days and 45 miles of the condominium or the county in which the condominium is located. Renters do have the right to inspect and copy the declaration, bylaws, rules, and all inspection reports, but that's where that right ends. The association can comply with the inspection requirements by having a physical copy of the records available for inspection or copying on the condominium property or the association property, offering the option of making the records available to a unit owner electronically via the internet. If they are posted on the association website or app, the association can merely direct the owner to the website or to the application, or the association can allow the records to be viewed in electronic format on a computer screen and printed upon request. Now, the right to inspect the records includes the right to make or obtain copies at the reasonable expense, if there's any expense, of the member. Now, the association is going to be required to allow the member or their authorized representative to, for example, bring their iPhone and take pictures of all the documents free of charge. If they bring their own copy machine, they are allowed to do so and make those copies free of charge from the association. I have seen people come and bring their actual printers, plug them in, and scan and make their own copies on their own printer. It does happen. The association has to maintain an adequate number of copies of the declaration, articles of incorporation, bylaws, and all amendments to those documents, the current rules, the question and answer sheet, here it is again, question and answer sheet, and year-end financial information on the condominium property to ensure their availability to unit owners and prospective purchasers, and can charge its actual cost for preparing and furnishing these documents to those requesting them. So you have to have an adequate number of copies of these documents. What does that mean exactly? I am not sure. I suppose, it would be based on the size of your condominium. And make sure that when you have these copies made, you're keeping track of how much it actually costs you to create those copies, because then you're able to charge that cost to whomever is requesting those hard copies. Now, as recently made effective, in response to a written request to inspect records, the association has to provide a checklist of all records made available for inspection and copying. The checklist also has to identify any of the association's official records that were not made available to the requester. And that checklist has to be maintained for 7 years. An association delivering the checklist creates a rebuttable presumption that the association has complied with its obligations. An association may and absolutely should adopt reasonable rules regarding the frequency, time, location, notice, and manner of record inspections and copying. However, in these rules, the association cannot require an owner to show any proper purpose for the inspection well, why are you inspecting the official records? You can't ask that. Or to state any reason for the inspection. Now, as I mentioned before, the official records of the association basically include any written record relating to the association, any written document relating to the association. However, not all records are accessible to the members. Records that are protected by the attorney-client privilege or the work product privilege relating to litigation or adversarial administrative proceedings, they're not going to be accessible. Information obtained by an association in connection with the approval of the sale, lease, or other transfer of a unit, that's assuming that your association has the approval authority and the right to, let's say, conduct background checks or maybe credit checks, that information would not be accessible to other owners. Personnel records of the association or its management company or its management company's employees, including disciplinary records, payroll, health insurance records. However, this does not include written employment agreements with an association employee or that management contract, or budgetary or financial records that indicate the compensation paid to an association employee. Medical records of owners, and you might say, why would we be in receipt of medical records of unit owners? Well, you know, sometimes owners come with their emotional support animals or their service animals. So you may be in receipt of medical records of owners. Any electronic security measures that are used by the association to safeguard data, including passwords, software and operating system, systems used by the associations, which allow the manipulation of data, even if the owner owns a copy of the same software used by the association, that's something like a Microsoft Word. That would fall within that category. All affirmative acknowledgements, again, this is having to do with assessment invoices or statements of account that Andy will talk about in his portion of the presentation. Now, social security numbers, driver license numbers, credit card numbers, email addresses, telephone numbers, facsimile numbers, emergency contact information, and addresses of a unit owner other than as provided to fulfill the association's notice requirements, and other personal identifying information of any person is not subject to access from owners. However, you can access the person's name, unit designation, mailing address, property address, and any address, email address, or fax number provided to the association to fill the association's notice requirements. Also, the association can print and distribute to owners a directory that contains the name, unit address, and all telephone numbers of each owner, although an owner can exclude their telephone numbers by written request to the association. Now, the association is not going to be liable for the inadvertent disclosure of this information if it's provided to the association voluntarily by the owner in an official record of the association. There is a way for an owner to consent in writing to the disclosure of personal information, contact information, which would otherwise not be accessible to unit owners. When posting, again, the association has to ensure that records that are not accessible to unit owners are not posted on the website. And if there's information included in documents that are required to be posted, again, has to be redacted out before posting the documents on the website. The association or its agents not liable for disclosing protected or inaccessible information unless that disclosure was made with a knowing or intentional disregard of the protected or restricted nature of such information. This should sound familiar from our website requirement discussion. And the association is not responsible for the use or misuse of the information provided to the association member, to an association member or their authorized representative in compliance with the Condominium Act, unless the association has an affirmative duty not to disclose that information under the Condominium Act. Now, a little bit about the attorney-client privilege. This is any record that provides an impression of the attorney, correspondence from the association's lawyer, those are protected by the attorney-client privilege, and the attorney-client privilege is held by the board. It's not held by the attorney. I cannot waive the attorney-client privilege. Only the association can, and that would be done by determination of the board. As I mentioned before, the official records, access to the official records has to be provided within 10 business days of the association's receipt of written requests for access. Now, the failure to provide that access within those 10 business days creates a rebuttable presumption that the association willfully failed to comply. A unit owner who's denied official records access is entitled to actual damages or minimum damages, and those minimum damages are 50 days per calendar day for up to 10 days, beginning on the 11th working day after receipt of that written request. Now, the person is then able, who was refused access, is able to get prevailing party attorney's fees, and any action to enforce the inspection and access requirements from the person who controls that access, who directly or indirectly knowingly denied access to the official records. A director or manager who knowingly, willfully, and repeatedly, which again means 2 or more violations in a 12-month period, fails to provide access to the official records commits a second-degree misdemeanor and must be removed from office, which is referencing something we discussed before. And the refusal to allow inspection or copying of an official record that is accessible to unit owners, within the time periods required by law in the furtherance of any crime is punishable as tampering with physical evidence or as an obstruction of justice. And this, of course, does not end our criminalization of certain acts pertaining to condominium associations. Any person who knowingly or intentionally defaces or destroys accounting records, again, pertaining to accounting records, we talked about this before, or who knowingly and intentionally fails to create or maintain accounting records that are required with the intent of causing harm to the association or one or more of its members commits a first-degree misdemeanor, is personally subject to a civil penalty, and is removed from office. Any person who willfully and knowingly refuses to release or otherwise produce records with the intent to avoid risk of detection, arrest, trial, or punishment for the commission of a crime, or to assist another person in doing so, commits a third-degree felony and must be removed from office. And the destruction of an official record in furtherance of any crime is punishable as tampering with physical evidence or an obstruction of justice again. And finally here, return of official records. An outgoing board or committee member must relinquish all official records and property of the association in his or her possession or under their control to the incoming board within 5 days after the election. An outgoing board or committee member who willfully and knowingly fails to relinquish the association's official records and property is subject to a civil penalty imposed by the division. Now, this concludes the first portion of the presentation. How long of a break are you giving him? Let me stop the share. Hold on one second.
Yeah, we're going to do about, we're going to let Andrew know that we're about to go on a break so he can come on in and join us in a couple of moments. Great job, Danielle, by the way. I know it's a lot of speaking and it's never easy and to do, but you did fantastically. But we're going to start back at the top of the hour. So if you want to go through a couple of the questions before you head out, we know we can't go through all of them. There are a lot, and we have almost 400 of you here today. But there are a few questions if you and Jonathan want to look at them real quickly. And while you're looking through some of the questions, I want to briefly go over the evaluation process one more time for those who might have joined in 5 minutes after we started. And so for those of you folks who are not seeing, a lot of you confuse the Q&A with the chat. Two different things, okay? So if you're not seeing the chat area on your Zoom interface, hit the little chat button at the bottom just so it shows up. Now, it is going to say that chat is disabled. That means it's disabled for y'all to send stuff to us, but we can send stuff your way. So make sure you can see the chat area. That is where we are going to a little bit later, towards the end of Andrew's portion of the presentation at the end, we're going to place a link for the evaluation. We need you to fill out that evaluation in order to get on the list to receive a certificate. That's what we use to populate the data after we cross-check with full attendance. So when we place that link into the chat later on, you're going to click on that link and it's going to take you to this page here. Okay. This is what you fill out. And some of the more important areas are right here, where it says name. You're going to type in your name as you want it to appear on the certificate. And do not use all caps, okay, because then it may look funny with the kind of font that is used. And you're going to fill out the rest of this sucker and hit submit. And after you hit submit, this is another question we've been getting in the Q&A during the presentation. This is where you will have the link to download and save today's slides. The last bullet point on the confirmation page says to save the slides from this webinar, click here. You're going to click on here, and that's what appears, and you can then download or print them. I recommend downloading them and saving them because this is going to be an ink hog. You're going to use a lot of ink and a lot of toner if you go and print these suckers. I'll go over this again a little bit later. I'm going to turn it back over now to Danielle and Jonathan, and I'm going to let Andrew know that we're almost ready for him. Back to you,
All
both.
right. So there are some questions here about who needs to have the milestone inspection report done, or who needs to have the structural integrity reserve study done. So the milestone inspection report, even if you have a mixed use, let's say you have a hotel and you have a residential condominium, if it's more than 3 stories in height, you're still going to be required to comply with the milestone inspection requirements. For the CEUs, though, your CEUs reserves are really only going to be for the residential. Excuse me, and does not include the commercial components. Now, for our associations that don't meet the 3 stories or higher requirement, you still do have reserve requirements. It's just based on the pre-existing statute, which is your roofs, your paving, painting, and any asset or item that has a deferred maintenance or replacement value of $10,000 or more. Those would be your reserve items. And they would still be subject to waiving or reducing reserves by majority membership approval. You wouldn't have any limitation there to do so. Let me see here. Somebody's asking about their 50-year certification having done, closing all permits. Does that count as a milestone? It might. It might count as a milestone. However, just know that your engineer or architect, whoever did that 50-year certification, will need to complete that phase 1 or phase 2, whatever applicable form is required by the Florida Building Commission. And you'll have to submit that form and whatever that 50-year certification report is to the building official to see if they will approve that as a milestone inspection. The milestone inspection, the general timeline is the 30 years, but the local building official can say that it's the 25 years, depending upon whatever local circumstances might dictate or require that shorter time period.
Hey, Danielle.
Yes.
I'm scrolling throughout the Q&A. A lot of folks are asking or a little confused or asking about the Q&A sheet you referenced earlier with the DBPR. Can you explain a little bit more about what that is and what needs to go in there, and how, and also being asked is how often that needs to be submitted and updated?
So let me see, there is a form for the frequently asked question and answer sheet. And if I can pull it up really fast, that would be
I think it might also be via that link I placed in there earlier, right on the DBPR website.
It is on the DBPR website. And it's having to do with like, do you have approval requirements? Let me see here.
And for those who may have activated, clicked on the chat button a little bit later, I'll put that link in there one more time, so you can get to the brand new condo section of the DVPR website. They did a really nice job. It's one of the better parts of their website, because a lot of it is so
You're talking about the
antiquated.
milestone inspection, structural integrity reserve part of it. It is nice. Okay.
Yeah.
While you're looking that up, someone's asking about if a board member position is not a paid position, so why would they be liable for any issues?
Oh, yeah.
Basically, when you agree to get on a board of directors, you are taking on with that a lot of fiducial responsibility and basically the need to do what's right for the association. So when gross negligence happens or malfeasance, even the insurance companies, in some cases, if it's blatant gross negligence or malfeasance, they may not cover you, and that's why you can be held liable.
Yeah. See here.
I was on mute. Also, while Danielle's looking, I want to this is not an attorney type of answer that I'm giving. I'm not authorized to do that, but I can mention that there is also a lot of confusion out there whenever we talk about websites for associations, and the word website is used and the word portal is used. As our firm resident nerd, I can mention that in these cases it's the same thing. So an association portal is typically something that's not so fancy looking. It's just a generic page on the back end where you have owner, username, and password. You log in, and then everything that's required to be there is be there. Then when the word website is used, it's essentially the same thing. But on websites, for example, you might have a public part that shows about the beauty of your association, amenities, event calendar. Then you have the back end, which is, again, owner, username, and password. Then you go to the back end of the website and you're seeing all of the required documents and things that must be on there. So when the term portal or website is used, they're typically synonymous when it comes to association website requirements. I just wanted to bring
And
that up because
many management companies have portals
right.
which fulfill all the requirements of a website. And in the case of RealManage, ours is totally transparent because it's a proprietary software.
Right.
So actually the board of directors has exactly the same access that we as managers have to that same portal.
There you go.
All
There
right.
you
For
go.
whatever reason, I'm not finding this form quickly, but it has to be updated every year, annually, every 12 months.
Okay.
It asks questions about like voting rights, maintenance fees, if there are ongoing legal issues. I'm still trying to find the form, but there is a form for it promulgated by the division.
I will continue to look for that too, and get an
Well,
exact link. But for now, I have the link on there that has a lot of the great Q&As, the FAQs over on the DVPR website. I placed
someone
that
had a
into the
quick
chat.
question about.
Oh, here, I just found it.
Okay, go ahead.
So I guess they just updated it October 1st. So this is what it looks like. I will share my screen so that you all can see.
You are wonderful.
Share screen. Okay, so this is your frequently asked questions and answer sheet. This is the form number here. This is referencing the Florida Administrative Code rule under which the division adopted this form, and this is the effective date. So they just updated this form recently. And this is a fillable form. You can, type whatever you need to in it and
Right.
then print it out. What are your voting rights in the condominium association? What restriction, excuse me, I can't speak, exist in the condominium documents? Am I right to use my unit? And these are just summaries, right? This is not going to be like, you know, you have to provide everything. You know, there's the note at the end that says that these are only summary in nature,
Right.
refer to the governing documents. And usually when we have clients who ask us to like provide for the answers and responses, we may point to particular sections and say, oh, see article da, 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 in the declaration and the rules and regulations. So yeah, it's just a bunch of different questions that provide a snapshot of your association.
Excellent. Excellent. Thank you, Danielle, for finding that. And folks, just one other thing before Danielle and Jonathan get to another question or two before Danielle heads out. This is the break time. We're going to get started again at about the top of the hour when Andrew comes in. So this is the time if you need a bio break or want to get a drink of water or something, this is the time to do it. Back to you, Danielle and Jonathan.
Let me see.
There was a quick question here on some new board members were announced. Should they have to update the information now, or can they wait till January 1? From a financial perspective, you're going to have to pay for it. If you do it now, you have to pay for it now, and you're going to have to pay for it again when you update it sometime the first quarter of next year, because it's due by April 30th. However, is there any legal precedence on that, Danielle?
Say again, I'm sorry, I was going through the questions.
Sorry, if they have new board members that just got announced,
Yes.
do they have to update their Sunbiz annual report now, or can they wait till January 1? Because it would be two separate charges if they did it now and then again in the first quarter of next year.
And you know what? It's only $35.
Right.
You know, I would suggest doing it now, so that you have the appropriate information up there, because, you know, in addition to what Jonathan was just saying about, you know, needing to change over your banking accounts, what have you, you don't want to create an agency issue. Meaning, if you have somebody who's listed on Sunbiz as being, let's say, the president of your board, and he's no longer on the board, no longer president of the association, you don't want anyone thinking that he has any authority to bind the association, let's say, to a new contract, right? So spend the $35, file the amended annual report, and then, you know, next year when your annual report filing comes up, do the filing. It's really a de minimis cost compared to what the trouble it could cause. So there's a question here about CEUs reserves and clarifying the timeline of when people need to have CEUs reserves in their budget for the December 31st, 2024 year. So you always have to fully fund reserves in your budget, your annual budget. Board doesn't have the option to waive or reduce any reserves. That's something that's left to the members. Now, if your budget is adopted before December 31st of this year, there is the option to waive or reduce the CEUs reserves, which will not be available if your budget is adopted after December 31st, 2024. So budgets adopted before December 31st, 2024, you could present to the members the vote to waive or reduce CEUs reserves in addition to the typical reserves for the 2025 fiscal year. And that's why I was saying, you know, you could, in effect, phase in your CEUs reserve funding if you were to reduce your CEUs reserve funding for that 2025 fiscal year. Now, if your budget is adopted after December 31st, 2024, you're not going to have that option. You're going to have to fully fund your CEUs reserves. But again, that's not something that the board can do. That's something that has to be presented to the members to vote on. Okay, so that's not a board question, it's a membership question.
Let's do one more question. I see Andrew's logging in and getting set up, so let's do one more.
Okay, so commingling CEUs reserves and non-CEUs reserves. No, you can't. You cannot commingle those two. Your CEUs reserves are sacrosanct. They need to be in a separate account. notwithstanding that you may be accounting for them separately on your books. You really need to have them in a separate account so that they're not touched inadvertently. You don't want to be you don't want to be commingling those funds. All right.
Oops.
See.
All right. How often, let's do this last one here because it's appeared more than once. How often does one have to be certified, like with this class? We went
So
over it earlier, I think.
the certification is particular for like new board members.
Right.
And notwithstanding that it's for new board members who are elected or appointed, you do have the continuing legal education requirements anyway. So you guys are going to be doing these classes constantly. I'm not sure
Right.
exactly what the continuing legal education will look like, what those credits and what the education for that will look like exactly. But yeah.
Well, I certainly didn't mean to stump you. I did that on purpose because this comes up all the time lately. The division has not yet been clear, not with us nor any other provider up to this point, about board member continuing education. Okay. So our suggestion is any courses, if you're a board member and you take any courses, whether it's with us, hopefully with us, or anybody else for that matter, I suggest you hang on to your certificates for whatever it is, whether it's a certification class, whether it's something about ESA pets, whatever it might be. Hang on to your certificates just in case the division comes back soon, we hope, and says anything that you've taken from July 1st on retroactively, can't say the word, retroactively will count towards your continuing education. We just don't know yet. So my
Right.
suggestion is take the courses if they're of interest to you. Hang on to the certificates for a rainy day, just in case they do count going back to July 1 and beyond. Hopefully that's clear enough for everybody. And Danielle, with that said, thank you. Gonna let
Not
you
a
get to
problem.
your,
Thank you guys. Thank you so much.
you are most
Enjoy.
welcome.
Good luck, Andy.
And
Hello.
hi, Andrew. Good to see you, man.
Hey, nice to see
Thanks.
you.
So we're about ready. Folks, if you can hear me out there and you're not near your computers and you're getting a drink, come on back. We're about to get started with part 2 of our session today for the condominium board member certification. I will remind one last time before Andrew gets started with parts 3 and 4 that the evaluation will be placed into the chat area towards the end, not the Q&A. Do not confuse the Q&A with the chat area. If you do not yet see the chat area, click the chat button at the bottom. It will magically then appear on your Zoom interface. It may say chat is disabled for you. That is true. You cannot send chats to us, but we can send stuff your way. So with that said, and again, I'll go over it again much more slowly at the end. We still have a lot of stuff to get to. I want to now turn it over to yet another one of the few in the state board certified specialists in condominium and plan development law, this time from our Pompano Beach location, and that is Mr. Andrew Black. Andrew.
Hello, Jeff. Thank you, Jonathan.
Hey,
Great
Andrew.
to see you as well. Thanks for hosting this. It's always nice to work with RealManage. And I applaud all 300 plus of you out there who chose to spend a Wednesday afternoon with 4 hours of condo stuff. I know it's a tall task that we ask of you, and we're at halftime pretty much now. Jonathan, is there anything you wanted to add now, or I'm assuming you all had a nice chance?
We already went through all that at the beginning, but it's being
Great.
really educational. So go to it.
Awesome. All right. Well, look, you all are stuck with me for the next 2 hours or so. And I'll share my slides and let me get to topic 3 as I'm scrolling to topic 3. I'm not going to be reading line by line. Obviously, you all got the handout. It's been emailed to you all. All right, here we go. So, I want to focus on what I think are the most practical areas we see. Our firm represents over 1,000 condominium associations all throughout Florida. And, we deal with a wide variety of matters, obviously, as general corporate counsel. But in the next two topics, topic 3 and 4, I want to focus on really the main issues we see. And before I dive in, and this perhaps was touched on a bit during the first part, but I always like to start any presentation I give by focusing on what the primary obligation that every member of the board has, which is you have a fiduciary duty to the owners. That means it's just a fancy word. You're in a position of trust. So every choice that you make as a member of your board, the primary focus should be what's in the best interest of the entire community. Your primary focus should not be what's in my personal best agenda or, how will this help me? Your thought process should be, am I making a choice that I, in good faith, think will benefit the entire community? And historically, when an owner has filed perhaps a breach of fiduciary duty claim, courts will analyze whether a board met its fiduciary obligations by analyzing whether the board used its reasonable business judgment. You all have probably heard that phrase. And all that means is how would an ordinarily prudent member of the board, how would he or she have acted if presented with the same facts? And if you would have acted in the same manner that an ordinarily prudent member of the board would have acted, courts traditionally grant pretty wide authority to a board to exercise that business judgment. And courts typically will not substitute its own judgment for the reasonable business judgment of a board. So I always like to think of it like this is the prism or the lens as I want you to view your role as a member of your board. Okay. Also, a couple other just very brief prelim matters. I'm going to be using the phrase document specific a lot. What does that mean? Obviously, every condominium association, you have your own set of governing documents, right? The original developer drafted that set. There's the declaration of condominium, the articles of incorporation, the bylaws, and any board made rules. Those governing documents, certainly the deck articles and bylaws, not always rules, but those are recorded in the public records of whatever county your condominium is in. Okay. And those are unique. So I would have no idea what your documents state on a particular topic unless I reviewed them, right? And lots of these topics I'll be going over, lots of them are document specific. So I just wanted to mention that. With that being said, let's jump into topic 3. We have topics 3 and 4. I think it works the best. I'll take questions at the end of topic 3 and certainly at the end of topic 4. Okay. Why is this not flipping? Give me 1 second.
What I'm seeing is the return of official records
Yes,
slide by itself.
I know. I got to get to the next slide. It's kind of being a little stubborn here. Let me stop sharing and I'll get right back to
Yeah,
sharing.
technology is wonderful when it works. the way you
We're
want it to.
having fun though, right? We're having fun. All right. There we go. Bear with me 1 second.
And while Andrew's getting to the page, just two quick things. Yes, if you got bumped off because your battery died or because you lost your internet connection, but you came right back within a couple of minutes, don't worry about that. Yes, you'll still get your credit and your certificate. The Zoom spreadsheet shows timestamps of when you come in and out. So as long as you're making the effort, you're good to go. And the other question that comes up a lot is, I know we have a lot of links in the chat, but the one for the evaluation is the one you must remember to use to be on the list to get a certificate. And yes, we will place that link again in the chat. We will place that link for the first time in the chat later on, so it's not confused with all the other ones that are in there now. Back to you, sir.
All right, great. Okay, so we're talking about financial matters. That's what topic 3 is about. I'm going to spend some time on transfer fees. Okay, and most of you, hopefully have heard of this concept. A transfer fee is the money that an association can charge in connection with a lease or a sale. Okay, per statute, and this is in chapter 718. You all know that's the chapter that applies to condominiums. The maximum that can be charged, it's $150 per applicant. Okay. Other than husband, wife, or parent, child, they're considered one person who's applying, but it's 150 max. The key is, however, the transfer fee authority must be in the deck, articles, or your bylaws. Okay. The authority to charge a transfer fee is not an automatic thing. Therefore, it's document specific. I cannot tell you how many times I've had sometimes property managers, oftentimes members of a board who are charging a transfer fee when the governing documents for that community don't authorize it. So if your governing documents, again, either your deck, articles, or bylaws, if they don't contain the transfer fee authority, under the law, you don't have the authority to charge it. If you do have that authority, again, it's a 150 max per applicant. Okay. Obviously, if it's a renewal of a rental agreement, you can't charge a second transfer fee. Okay. And that transfer fee, practically, it's used for the association when they engage their third-party company to do the background report. Okay, where they run the criminal history, the financial history. That's what that fee is used for. We get asked a lot, well, the buyer or the tenant, they are from another country. It's going to cost us more than the 150. Can we charge more than the 150? The answer is no. The 150 is that maximum amount. If you have an actual cost that you incur more than 150, it's just deemed a common expense of your association. Another fee that's often charged in connection with the rental of a unit is a refundable security deposit. The authority, same thing. It's set forth in 718, but what chapter 718 of the Florida statute says, it says that in order to charge the security deposit, your governing documents must specifically provide for that authority. If your governing documents do not authorize you to charge a security deposit in connection with a proposed rental, you can't charge one. Okay. If your documents allow a security deposit, the maximum amount is just 1 month's rent. And very important, a security deposit, it's a refundable amount. It's to protect against damages to the condominium property that may occur while the tenant is there. If the tenant doesn't cause any damage, that deposit must be returned to them. And there's a time frame and a procedure to do that. So if you're a manager or you're on a board and you collect security deposits, make sure you're aware of the requirement to return them if there's no damage. Likewise, if there is damage, you're required to send notice to the tenant, letting the tenant know that you're imposing a claim on that security deposit for whatever that amount is. Okay, so that's a transfer fee and a security deposit that can be charged in connection with the transfer, of a unit, provided that your governing documents authorize that. The next topic is something called an estoppel certificate. We have a bunch of slides on this that I encourage you, obviously, to read when you have time. The main point I want to highlight is the word estoppel essentially means that a party is prevented from asserting a right. So what that means practically is an estoppel certificate is something that's usually requested by a title company in connection with the sale of a condominium unit. And what basically the new buyer wants to know is how much money remains outstanding for that particular condo. And Chapter 718 of the Florida statutes has a detailed form of exactly what the estoppel certificate must include. But the main thing it shows is how much money is owed. And if outstanding monies are not reflected on the estoppel certificate and the closing of the unit goes through, the association is prevented. You're stopped from asserting a right to those funds that were not included on the estoppel certificate. This slide here, it goes through exactly what's required to be shown. It includes such things if there's any assigned parking spaces, what the charge for the estoppel certificate. There's a statutory schedule of fees that caps how much an estoppel certificate or how much how much can be charged. It certainly depends. The amount that can be charged will depend on whether the owner is delinquent or not, as well as whether the requesting party wants a expedited estoppel certificate. Okay, so usually this is handled by your management company. Certainly, if the particular unit owner is with your law firm for collections, the law firm will handle the completion of the estoppel. This slide here walks you through what the maximum charges can be. But again, the main takeaway is that you need to make sure you include what funds are owed when you receive an estoppel certificate request, or else you'll be stopped. You'll be prevented from seeking those funds. Okay. Also, if you're a manager, you certainly are familiar with various questionnaires that a bank sometimes will want responses to. When a bank is thinking about issuing a mortgage, a loan, right, for someone to buy a condominium unit, part of the risk analysis that bank will do is what is the physical and financial condition of the condominium, and they'll submit various, sometimes very long questionnaires, oftentimes to the property management company if you're a board that does have a property management company. This slide just walks you through that you're allowed to charge a fee for responding to those bank or lender questionnaires. Just want to point out at the bottom of this slide 96, the last sentence that says the responses herein are made in good faith. That should be included in every single lender questionnaire. In addition, in my opinion, to the estoppel certificate as well, to let the requesting party know that you're doing your best to provide accurate information. Other, just real quick, other forms that are common in a condominium transaction. I want to spend some time on the first one. The frequently asked question sheet, the FAQ, here it's identified as the condo question and answer sheet. This is a required form that every association must have. There's about 6 or 7 questions. It's pretty much what are the assessment amounts, what rental restrictions are there, what are my voting rights. It's a form that the state of Florida, via the Division of Florida Condominiums, they draft this sort of sample form, but the answers to that sample form, to the 5 or 6 questions, that needs to be completed and needs to be updated annually, and certainly is something that a new owner is entitled to, and it's part of the official records of the condominium. Regarding the specific unit owner, what the unit owner needs to disclose, the list is right here. Obviously, and this is at the seller, right? This is at the owner, the party that's selling. This is at the expense of that owner, but certainly a copy of the governing the documents you see right there, the deck, articles, bylaws, rules, as well as that frequently asked question sheet. There's also what's called a governance form that the state of Florida, via the Division of Florida Condominiums, they publish sort of a helpful guide to essentially, congratulations, you bought a unit in a condominium. Here's some things you should know. I'm sure if you're on your board, and obviously property managers, if you've never lived in a condominium, certainly it's a unique experience, right? I mean, the whole concept, if you really break it down, it's shared ownership with shared walls, right? You own your individual condo unit, but you also own a pro rata share of the common element property with all of the other unit owners. And it's really a slice of life, right? So the state of Florida, like I said, via the division, publishes a helpful governance form that owners get to see. Okay. Want to go on to some more financial topics that the state of Florida wants to make sure is part of the board member certification course. And this is dealing with when an owner or a tenant violates the rules, right? No commercial trucks, and they bring a commercial trucks. What are some of the enforcement rights we all have? Okay. The statute, and this is in 718. So very important, your governing documents do not need to authorize the ability to levy a monetary fine against an owner for violating the rules, nor do the governing documents need to specifically authorize the ability to suspend an owner's use rights of the common elements if they break the rules. Rather, that authority is set forth in Chapter 718. So every condo association in the state of Florida has the ability to levy a monetary fine or suspend the common element use rights if an owner violates the rules. Okay. The main thing is you need to have an independent committee established. Lots of times it's called a fining committee, a grievance committee, infraction committee, whatever you want to call it. It needs to be an independent committee made up of at least 3 owners who are not on the board, not officers, not related to board members or officers, can't be employees, management company. It can't be any of those individuals. They need to be truly independent. Now, the board is the body that votes to approve who serves on that independent committee. If you don't have a committee established, you cannot use the fining authority or the common element suspension authority. So you need to have that independent, impartial committee established. And the way it works is that owner or that tenant who's violated the rules, they're afforded the opportunity to attend a hearing before that independent committee. And there needs to be a notice sent to that owner or that tenant, whoever broke the rules. That notice must be sent 14 days, at least 14 days in advance of that hearing before the independent committee. That 14-day notice will confirm, the date, time, and location of that hearing. It'll let the party know what rule they broke and what the fine amount was. And this is per statute. A fine cannot exceed $100 per infraction, nor can it exceed $1,000 in the aggregate for a continuing infraction. So simple hypothetical, your condominium does not allow commercial trucks. John Doe has a commercial truck. You can fine him $100 a day up to $1,000. So if the truck is there for 10 days, $100 each day up to that $1,000. You send the 14-day notice to John Smith. You've been fined $100 a day for 10 days, $1,000 fine. You can appear before that hearing. And at that hearing, you want to think about it. It's like a mini due process, trial, right? Where the state attorney who's prosecuting the case, that's the association, and the defendant is the unit owner or the tenant, whoever broke the rule. And that independent committee, they're like the judge / jury. Now, it's not the role of the independent committee to negotiate some sort of plea, agreement with the unit owner who broke the rule. The role of the committee is simply to either thumbs up or thumbs down, right? Either confirm or reject that monetary fine, or to confirm or reject the suspension of common element use rights. Okay. At the conclusion of that hearing, if the committee confirmed that fine, it's due within 5 days. And also very important, a fine cannot be the source of a lien against a unit. What does that mean? Well, hopefully you all know, as a condominium owner, you pay your regular assessments or maybe a special assessment that was properly adopted. If an owner does not timely pay a regular or a special assessment, the board can file a claim of lien in the public records against that unit. And if the owner doesn't bring his or her account in full, the association can file a foreclosure lawsuit to foreclose that claim of lien. However, a fine, a monetary fine, is not an assessable sum. It can't be the source of a claim of lien. It can be added to the owner's account as a cost, but it's not part of the assessments. Okay. Now, like I said, in addition to finding if an owner or a tenant breaks the rules, they can also suspend the common element use rights. Common element use rights really applies best if you have like a key fob or some sort of electronic access that you can turn off, like the pool, the clubhouse, gym, those types of things. It's the same process if you're suspending common element use rights. It's the same process if it's for a rule infraction. You need to follow that 14-day notice and hearing before that independent committee. Now, what the statute says is you can also suspend the common element use rights if an owner is more than 90 days past due in paying a monetary obligation, whether it's an unpaid assessment, regular or special, or an unpaid fine. If that monetary obligation is more than 90 days past due, it's in 718, right? It's in chapter 718 of the Florida statutes. Your governing documents do not need to include this authority. A board can suspend common area use rights for a monetary obligation more than 90 days past due. The key takeaway, if you're suspending rights for an unpaid sum, you do not need that 14-day notice and hearing before an impartial committee. All right. All you need if you're suspending use rights for more than 90 days, you just need a meeting of the board, regular 48-hour notice board meeting. The agenda, one of them is suspending common element use rights for delinquent units owners. If a majority of the board approves suspending those common element use rights, you simply need to send written notice to the owner and or the tenant, letting them know that those common element use rights have been taken away and they'll be reinstated once that monetary obligation is paid in full. Just want to wrap up the common element use right topic in red font. Any common elements suspension does not apply to the ability of an owner or a tenant to access their unit, obviously, right? So they can use the elevator, they can walk in the hallways, they can park their car. Okay, you can't turn off utility services. Water needs to be left on. So, like I said, practically, it's best applied to things where you can easily turn off, usually by some sort of electronic fob, such things like the clubhouse, gym, and pool. Another enforcement right I just want to touch base on, if an owner is more than 90 days past due and their past due amount is greater than $1,000, you're allowed to suspend their voting rights and owners' voting rights. You do not need the 14-day notice and hearing before an independent committee to suspend voting rights that are more than 90 days. Please note, and this comes up a lot, especially we're in election season now, a voting rights suspension is not automatic on the 91st day. Rather, the board still needs to have a meeting, regular 48-hour notice board meeting, where the agenda includes voting, suspension of voting rights. And then after the board approves suspending voting rights for owners that are more than 90 days and greater than $1,000, you need to send written notice to the owner. Okay. Again, more than 90 days, more than $1,000. The statute has clunky language that says proof of the obligation to pay must be provided to the owners 30 days before any suspension takes effect. In my opinion, that can just mean the payment coupon or some written account statement that's sent to them 30 days before they can't vote. Okay. If you do suspend voting rights, let's say you have 100 total units. If you suspend the voting rights of 10 units, it reduces the total amount of units that you have to calculate quorum. So let's say quorum for your meeting of the owners is a majority of all owners. If you suspend voting rights of 10 units and you have 100 total units to calculate quorum, you subtract 10, so you have 90 total units. It would be a majority of the 90, not a majority of the 100. Okay, so if you suspend voting rights, it reduces the total number of units when you're trying to calculate quorum and whatever approvals you all need. Okay, let me touch on a couple more items in topic 3, then I'll take questions. Now we're getting into the annual financial task that a condominium has. A budget, obviously, an annual budget must be adopted every year. Okay, there's two sides. There's the operating expenses and your reserves. I'm not going to get into about CEUs reserves and non-CEUs. You guys went in depth into that topic during the first half, but it's just important to know that, and this is a list of some common operating expenses, and the annual budget each year, it's supposed to be a good faith estimate of what those operating expenses will be. So you take a look at last year and you make whatever adjustments you all need. The board meeting to adopt the annual budget, the notice must be mailed to owners and posted, and a copy of the proposed annual budget must be included. That notice is sent, mailed, and posted 14 days prior. Okay, so it's not 13 days, not 12 days, 14 days prior. And there's an affidavit that must be signed by the association agent who sent the notice, attesting, right? Basically confirming that notice of that board meeting where the annual budget will be adopted was mailed and posted 14 days prior. I'll get into this a bit soon, but if you have the signed consent from an owner to use his or her email address to send official association things to them via email, you can obviously just email the 14-day notice to that owner, and you can save a stamp. Okay. All right. Obviously, reserve items, you want to think about it. These are rainy day funds that you're collecting each year. Okay. So when the time comes that you need to replace one of the reserve items, you have those rainy day funds set aside to pay for that. And that will help avoid a large special assessment at that time. Okay. Now, hopefully you all, certainly if you're more than 3 stories or taller, you all are well aware by now, and I'm sure you heard a lot about it during the first half, but you need to get that structural integrity reserve study done by December 31st. But all reserve studies, okay, the way they calculate how much money you will need, and it's set forth in this slide here, is they look at what the remaining useful life of that reserve item is. Okay. So let's say your parking lot's going to need to have brand new asphalt in 10 years. You have 10 remaining useful years left. And your reserve study calculates it's going to cost $100,000 to redo your parking lot. In order to fully fund that parking lot reserve, you're going to need to what? Collect $10,000 each year, right? 10,000 year 1, year 2, year 3, until at the completion of the 10th year, you have that $100,000 there to use to replace that reserve item. Okay. Now, under the statute, and again, we talked about CEUs in the first half. But if it's a non-CEUs reserve item, the statute allows each year, it allows the board to present to the owners the ability to only partially fund that non-CEUs item or to completely waive funding that non-CEUs item for that year. In order to either partially fund or waive the reserve funding for a non-CEUs item, you need the approval of a majority of all owners. So 50% plus one of all owners. It used to be just a majority of the quorum who was present at a meeting of the owners, but that was recently changed to a majority of all owners. Regarding the CEUs reserve items, and I know you already went through this, but for any annual budget that's adopted after December 31st of this year, you can no longer waive or partially fund the CEUs reserves. So you still have about a month and a half or so if you're thinking about partially funding or waiving CEUs reserves for the annual budget for 2025. You still have a little time left. But any budget that's adopted after December 31st of 2024, your CEUs reserves must be fully funded. For non-CEUs, like I said, you can vote to partially fund or waive each year. You need a majority vote of the unit owners. Okay. Now, the method to have reserves, and again, I know we talked about this in the first half, is either you have what's called straight line reserves. Some people call it component reserves or individual line item reserves. So the method you use is either individual reserve items or a pooled account where you have multiple reserve items in that pool. Okay. If you have individual reserve items, you can only use the funds for that specific reserve item. You cannot use it for an alternative use unless you get approval by a majority of all owners. If you use the pooled method of reserve accounts, so you have multiple line items in the same pool, you can obviously use the funds in that pool for any item in that pool, but you can't take the funds in a pooled reserve account and use it for something that's not in that pool. Also, and I know you again touch base on this, but I think it's good to highlight it again, is that you should have, if you use the pooling method, you should have and you're 3 stories or taller, you should have separate CEUs pooled reserve funds and non-CEUs pooled reserve funds. Okay. If you are going to be asking the owners to vote on anything regarding reserves, whether it's to waive or partially fund reserves, or whether it's to use reserve funds for an alternative use, you must include the language that's on this slide at the bottom in all caps in a font size larger than the font size that's used on the rest of the limited proxy. It's basically disclosing to the owner that them voting to either partially fund or waive reserves or using reserves for an alternative use that could lead to a special assessment in the future. So if you're on your board or you're a property manager and you're going to be presenting to the owners a item to vote on regarding reserves, make sure this is in your limited proxy. And it's probably a good idea to run the voting package by your attorney before it's mailed. Okay. One last financial item in topic 3, and then we'll take some questions. The other annual financial task that you on your board must do every year is you're required to have a financial report each year. Owners obviously are entitled to a copy of that financial report. Okay. And I'm going to go back to that slide in a second, but the level of financial reporting is set forth in Chapter 718 of the Florida statutes. And it's based on what your annual revenues are. And the chart is right here. Okay. If you're between $150,000 and $300,000, you must do compiled financial statements. If you're between $300,000 and $500,000, you must do reviewed financial statements. So one step up. And if your annual revenues are $500,000 or more, you're at the highest level. You need to do an audit for that year. And if you're 150 or less, it's just a simple report of cash receipts and expenditures. Let's say your annual revenues are $400,000, okay? Per statute, and it's right on this slide, you would need reviewed financial statements. Let's say your board for that year says, look, we know we're only required to do reviewed financial statements, but we think it's a good idea. We want to do a higher level of financial reporting. We want to do an audit for that year. That's certainly up to the board. It's a board vote. The board on its own can vote to increase the level of financial reporting. However, and you can see where I'm going with this, the board on its own cannot reduce the level of financial reporting. Rather, the owners must approve a reduction of a level of financial reporting. And under the statute, owners cannot vote to reduce a level of financial reporting 2 years in a row. Okay. So that's topic 3. I want to take some questions, and I'm sure we spoke about this already, but I'd like to make a mention of this. Obviously, we do our best to give, general information to you all today. What I'm going over, right, obviously should not be, and this is my attorney, spiel, right? But this should not be construed as direct legal advice for your specific condo, your specific fact pattern. A lot of these things are either document specific or the facts need to be analyzed in a case-by-case way. So certainly we suggest getting with whoever your current association attorney is to address specific fact patterns for your community. With that being said, one of the questions is, what is fully funding reserves? Hopefully, my fact pattern helped a bit, but fully funding means you have to know how many remaining useful years that reserve item has. So again, let's say your parking lot has 10 remaining years left, okay? In 10 years, you're going to have to redo the whole parking lot, new asphalt. It's going to cost you $100 grand. To fully fund means you need to collect $10,000 each year. So at the end of the 10 years, you have that fully funded $100,000 amount. We got a question about using pooled reserves. Any condo, no matter what size, can use pooled reserves. Okay, so you don't need to be 3 stories and up. If you're 1 or 2 stories, you can use the pooled method. What I will say is if you currently have individual reserve items, some people call it straight lines, some people call it component, but if you use individual reserve accounts and you want to go to a pooled reserves, you can't take the existing funds in the individual reserve accounts and just dump them into the pool without getting an owner approval first. Because if you did take existing funds in those individual reserve accounts and you just dumped it into a pool, that would be using reserve funds for an alternative use, and you need an owner vote to do that. What you could do is if you have individual reserve accounts, but you wanted to create a new pool for new reserve items, you can do that and just put into that new pool new funds that you collect from the unit owners. That can be done just by a board vote. But to convert existing funds from an individual reserve account into a pool, you need that owner vote. Okay. We got asked about estoppel charges, and we have a slide that walks through what those charges are. There can be a rush charge. So first of all, there was a little bit confusion. So a transfer fee is just a transfer fee, and an estoppel fee are 2 separate things. A transfer fee is just the fee charged in really to do the background report on someone that wants to buy or rent. That's the 150 cap. That's a transfer fee. Okay. A estoppel certificate is something else. That's when that's a specific form usually requested by a title company, and they want to know how much money remains outstanding, and there's that statutory form. And an estoppel certificate can be up to $299 plus $179 if the owner is delinquent, plus $119 if a request is made to have it rushed within 3 working days. So I suggest for that question regarding the estoppel fee charges, to look at that slide that goes through that. But a transfer fee is something else, and that's a 150 cap. That's the max that you can be charged. I got another question about transfer fees, where this question, they call it an interview fee. You can call it anything you want. Under the statute, it's deemed a transfer fee. And your governing documents, like I said, must authorize the ability to charge that transfer fee. Whether you call it a screening fee, an interview fee, it's 150 is the max, and your documents must authorize that. Okay. Regarding the fining committee, okay, whether you call it a grievance committee, whatever title you want to use, the statute authorizes the board to create that. So your governing documents do not need to have specific language authorizing the board to create that independent committee. The authority is right in the statute. So thank you for that question. The independent committee hearing, in my opinion, that is open to other owners if they want to attend. We had a question about commercial trucks. Someone asked, in the statutes in chapter 718, does it talk about commercial vehicles or commercial trucks? The answer is no. It's nowhere in 718 that governs condominiums. There was recent language that was made to chapter 720 of the Florida statute, but that only governs homeowner associations. And I certainly don't want to go over that during a condominium board member certification course. Okay. Okay. Let's see. We got a question about fining. What recourse does a board have if an owner doesn't pay a fine? As I mentioned, fining cannot be the source of a lien, right? It's not an assessable sum. So fining also doesn't really cure the underlying infraction either. So the recourse if an owner doesn't pay a fine is it could stay on the owner's account. And when they go to sell, you can reflect it on the estoppel and collect it at closing. Technically, an association could, file like a small claims court action to seek payment of that fine. Usually for a maximum $1,000, you would be spending way more to pursue a small claims action. So that's really not usually the best way to spend the association funds. But if an owner doesn't pay a fine for 90 days, as I talked about, you could have a board meeting and suspend their common element use rights. So I had a few questions on that. Someone asked a good question about suspending common elements use rights. That does not include their ability to rent their condominium. Okay. So if their documents allow them to rent, they can rent, whether they're breaking the rules. That's not, you can't suspend their ability to rent. You can only suspend their ability to use the common elements. And like I said, that's typically such things as the pool, clubhouse, and gym. Okay. The 14-day notice of that hearing, it's at least 14 days. If you want to send it 20 days, 30 days to be safe, there's certainly no pressure about that. Regarding sending the 14-day notice of the board meeting when the annual budget will be adopted, you can only send it exclusively via email to an owner if that owner has given you their previous signed consent that they wish to receive notice via email. If you do not have their signed consent to use email as the official way to send them official association things, you have to mail the notice to them 14 days. You can email it as well, but you need their signed consent to only send it via email. Again, in our opinion, CEUs and non-CEUs should be kept two separate things, so to not confuse them. Okay, take a couple questions. The level of financial reporting, as I mentioned, we have a slide that goes over that. The language is directly in 718. It actually outlines what those annual revenue chart are. So it's right in 718. I got a question on that. Okay, let me take a couple more questions and then we'll hop into topic 4 because we've got about an hour left. We got a good question about fining, where let's say an owner has my commercial truck fact pattern. The maximum fine is $100 a day up to $1,000. So if the commercial truck is still there, you can't just reset that clock. So it's $1,000 for the same infraction. Okay, we got a question. Is it wise to have our attorney to look over our condo docs to verify certain things in the bylaws? Absolutely. I mean, technically, there's something called the unauthorized practice of law. So really, a non-attorney shouldn't be in interpreting what your governing documents say. Obviously, managers can point out your bylaws say this, but to really get an interpretation of what that means, you should get with your attorney. Regarding suspending common element use rights, enforcement can be hard. Like I said, practically it works the best if you have some sort of electronic fob that you can turn off. If you don't, I mean, I don't know of any board that has someone, standing guard at the gym to make sure John Smith doesn't walk through. At the end of the day, if they're violating that, they're using the pool when their rights have been properly taken away, you can get with your association attorney for formal enforcement. We got a very good question about the financial reporting requirement. Some governing the documents will actually expressly state the association must do an audit each year. If your governing documents expressly require an audit, in our opinion, you should do an audit, even if your annual revenues do not reach that $500,000 threshold in the statute. I know I've worked with several clients that have documents that require an audit, even though their annual revenues don't reach that $500 threshold. And we advise them to amend their bylaws to take that out. Certainly, most bylaws require an owner vote. So get with your association attorney to do that properly. Okay, we got asked a question about who can contact the attorney for the condominium. Seems like a simple question. You get asked this a lot. Our firm, our client is the corporation, the association, right? That's who our client is. We don't represent any individual member of the board. We don't represent the manager. We don't represent any individual owner. However, the association, that corporation, is governed by the board. They're the body that makes the policy choices. They're the ones that can bind the association by entering into vendor agreements. So the authorized contacts of the association are determined by a majority of the board. Usually the manager is an authorized contact, and certainly usually one or two, sometimes more members of the board. Those are usually the authorized contacts. It's very rare that an individual owner would be authorized just to call the association's attorney anytime he or she wanted to. You can imagine the potential chaos that could create, not to mention the expense involved. Okay, let me take a couple more questions and then we'll get to the topic 4. If I don't get to your specific question, it's likely very fact specific. I mean, I'm getting questions asked about particular owner infractions and how do they address a particular owner thing. Okay. We got asked a very specific question about, which counties are still under a state of emergency. I candidly don't know the list just off the cuff. right now, but I would encourage you to visit the state of Florida site, and there are the most recent orders from the governor on which counties are still under a state of emergencies. Okay. Alrighty. We had one question about the governing documents require owners to provide a unit access key to the condominium, and some owners aren't responding and haven't, done that. The options are, obviously, if you have that independent committee established, you could find them. Certainly, there should be a written violation letter sent demanding compliance by a date certain. And if they don't comply, certainly you can refer that matter to your association attorney to handle that. Last question, and I promise this time, and then we're going to get to topic 4. Can an association charge, sometimes it's called a capital contribution for new unit owners to offset, operating costs or to help replenish a reserve account or something like that? The short answer is in a condominium association, the state of Florida has held no, you cannot charge a capital contribution to a new owner. The state of Florida, which I don't necessarily personally agree with, but they're the ones that if there was a complaint filed, they get the jurisdiction to rule on this. They have held that the maximum fee in connection with the sale is what? The $150 transfer fee. That's it. So no capital contributions in a condominium association. All right, we're going to move on to topic 4. We've got about an hour left, and we want to make sure we hit all of the fun stuff. Again, I'm not going to be reading line by line, but meetings of the members, those are the owners, right? And there's really only 2 types. There's either a meeting of the owners, that's where the owners vote, or a meeting of the board, where the board votes. That's it. So if you're confused about what type of meeting is this, the main question you should ask is, who is voting? And if the owners are voting, it's a meeting of the owners, the members, right? The members of the association are the unit owners. Obviously, you have your annual meeting of the owners, right? That's where the election takes place. Okay, you're required to have an annual meeting, right? Each year. There could also be special member meetings as well, and I want to focus on that. The notice of a membership meeting, of a special membership meeting, must be mailed and posted 14 days in advance, right? The notice must contain an agenda. Again, you can only exclusively send the notice via email only if you have that owner sign consent to use their email, okay? Proof that that notice was sent properly, you have an affidavit of mailing that whoever sent the notice, they sign, and that's kept in the official records, okay? Again, this slide is talking about email notice, right? Electronic transmission. You can only do it as the exclusive way to those owners who have consented in writing. The fact that your new owner application has a space for an owner to include their email address is not the same thing as an owner specifically stating, use this email for official association things, okay? So make sure you have that signed consent if you want to exclusively use email notice. Okay. If your condo, okay, has 150 or more units, you hopefully know you need a website. Okay. If you have less than 150, you don't have to. But if you're 150 or more, you have to have a website. And the statute specifically requires the notices to be on that website. Okay. So just be aware of that. For every meeting of the owners, whether it's the annual meeting or a special meeting of the owners, a special meeting of the owners is when owners are voting on something. It could be a vote to amend the bylaws where you need an owner vote. A special meeting of the owners could be a vote of the owners to vote to, partially fund reserves. It could be a vote on the owners where you're doing a material alteration to the common elements and your documents require an owner vote. Okay. It's where the owners vote. For every special meeting of the owners and for every annual meeting, you need a quorum of the owners. Quorum is just a fancy word. It's the minimum number of owners that must be at the meeting, either physically at the meeting, either present via proxy, or if you have properly implemented electronic voting. If an owner votes electronically, that electronic vote counts for quorum as well. If you don't have quorum, no business at the meeting can be held. Okay. Just like meetings of the board, which we will address soon, owners can participate, obviously, in meetings of the owners. They have the right to speak on agenda items. They also have the right to record, whether, their cell phone or audio. They have that right. A board cannot prevent an owner from recording. The board could adopt rules regarding recording, such as requiring owners to notify the association a certain amount in advance if they're going to record. If this is an area of concern for your board, I would certainly get with your association's attorney, and he or she should be able to assist you with drafting some reasonable rules regarding the recording process. Now, voting by proxy, this can sometimes get a little confusing in my experience with certain members of the board, or quite frankly, some managers. For owner votes, like amending the governing documents or waiving reserves, owners can vote by what's called a limited proxy. That's where I'm the owner. I'm John Smith. I can't or don't want to physically show up to the meeting. If the meeting's to, let's just say, vote to amend the bylaws, I, as the owner, John Smith, can vote via limited proxy. I actually check off, I, John Smith, am for. I approve whatever the action is. I date the limited proxy. I sign the limited proxy, and I give my completed proxy to whoever the proxy holder is. Oftentimes, if it's left blank, it'll just default to a member of the board. Okay. And that, if I, John Smith, vote via limited proxy, it counts for my vote and it counts for quorum purposes as well. That's the most common use of a proxy in a condominium context, where the owners are voting on something and an owner actually gets to cast his or her vote. A general proxy is really just used for quorum. That's it. Okay. Just want to mention, I know you went through the election process during the first part, but there's no proxy voting in elections for the board, right? You vote via the ballot and envelope process. So let's say you're having a special meeting of the owners to amend the bylaws. All right. Again, I, John Smith, if I don't want to physically show up, I can vote via limited proxy. I get to cast a vote however I see fit. Those proxies are valid for 90 days from the date of when the meeting is held. So let's say to amend the bylaws, you need 75% of all owners to approve it. You have a special meeting of the unit owners. You're a few yes votes short. That meeting can be recessed and reconvened, basically continued to a later date to give the association more time to collect votes. It can only be recessed and reconvened, i.e. continued, for up to 90 days, right? So that proxy is valid for 90 days. And if I submit my limited proxy, I can revoke it. I have the pleasure. It's my vote. If I change my mind, I can submit a new limited proxy. It's the latest dated limited proxy that controls that vote, okay? So that's meeting of the owners. The other types, and that's where owners vote. And again, you need quorum of the owners for the meeting to happen. Obviously, the other types of meetings in an association are meetings of the board. That's where the board votes, okay? I talked right at the start, and here's a slide just to kind of hammer this point home, that every board member has a fiduciary duty. Just a fancy word, you're in a position of trust, okay? So you need to utilize your business judgment. Sometimes if you use your business judgment, things don't turn out the way you want it to, okay? That happens. Just because something doesn't turn out the way the board wanted to does not mean that the board didn't use business judgment or somehow breach its fiduciary duty, okay? Again, utilize your licensed professionals. If you're on a board and you have an insurance question, utilize your licensed insurance professionals. If you have a management question, utilize your licensed property managers, licensed accountant. Certainly, if there's a legal matter, use your attorneys, okay? Part of the obligation of the board is to rely on those licensed professionals, gather all the information you can to assist in making whatever choice you want to, okay? So I just wanted to spend some time on that. Board members, the decisions are made by a majority of the board, okay? No one on the board has special powers to bind the association by him or herself, okay? That even means the president on his or her own can't sign a contract binding the association just because they're the president. Contracts need to be approved by a majority of the board. Now, what can happen is a majority of the board can expressly authorize a single member of the board to take certain action to bind the corporation, right? But that decision of a majority of the board to assign that authority to one or two members of the board, that should be approved by a majority of the board at a duly noticed board meeting. And there should be minutes of that board meeting reflecting that that action was taken, okay? You know, every manager, and I'm sure if you served on your board for any length of time, can share with you quote unquote war stories about boards that are just dysfunctional. And there's a split, you know, it's a 7-person board and it's 4 versus 3, or it's a 5-person board and it's 3 versus 2. And it can be very difficult in those types of fact patterns because invariably things can turn, emotions can run high, right? And, you know, it's easy for me or it's easy for the manager to say, you know, stay professional, stay courteous, remember that you're, a board member. Oftentimes you're an officer of a corporation. You have a fiduciary duty to the entire community. So all personal attacks and all that stuff have no place in a board. That's our kumbaya speech, right? Practically, it doesn't always happen like that, but I still will always pound that drum and stand on my soapbox and encourage every member of the board, take the high road. Okay. Especially, I've seen some things in emails that are unbelievable. And what I tell my board members is never put anything in writing that you don't want read out loud by a judge. It's as simple as that. Okay. And there's a good 24-hour rule, right? If emotions understandably are running high about something, don't just fire off some, email. Kind of let it breathe before you hit send. I can't tell you how many litigation cases our firm has been involved with where an email from a board member is required to be produced as part of the discovery process, and the board member tries to explain the context in which the email was sent, but it really doesn't do much good. Obviously, board members cannot accept a kickback. Okay, that's a no-no. A kickback, in the most common sense of the term, is where, let's say, a vendor gives a board member some money on the side for approving that contract. Okay, that is a crime. Okay, and obviously can't do that. You all know that, but I want to make sure that we just spend a brief moment on that as well. Okay. Also, while credit cards can be used, debit cards cannot be used. Okay. So it's right in that slide, but just know that. Hopefully you all don't need to deal with a board member who has been charged with a crime. But if you have a board member that's been charged with a crime, make a star on this slide, because they must be removed while those criminal charges are being dealt with. So it really is not innocent until proven guilty. In the condominium context under 718, it's reversed. So just a charge of that type of criminal conduct, just be aware of that. You get asked a lot. We have a rogue board member. How do we get rid of that member of the board? Or we have a group of owners. Our board is horrible. How do we get a new board? Okay. Here are the ways. And I'm going to add a seventh one at the very end, which is kind of an obvious one. But obviously, to get off the board, a board member can resign in writing, right? Verbal resignations are very problematic under the eyes of the law, because intent and what did they actually say, it can be problematic. So if a board member wants to resign, just him or her should just put it in writing. Okay. The recall process. Okay. This is governed under the statute. It's in 718. Any board member can be recalled and removed from serving without cause. There doesn't need to be a reason. It can be because the wind blows a certain way, right? A board member can be recalled and removed from office if a majority of all owners agree. Okay. The most common way is something called recall by written agreement, where a majority of all owners sign, and it's a specific, form that this recall agreement needs to be in, and it's served on the board, usually via certified mail. You could use a process server as well. But again, recall can be done without cause. All right. If you're a group of owners and you think you have majority support to recall one or more members of your board, we suggest getting with a Florida licensed attorney who's experienced to make sure that you're doing it procedurally correct, right? Excuse me. In the same fashion, if you're on the board currently and a majority of the board gets served with a recall attempt, we recommend getting with your association's attorney as soon as possible to review whether it was done procedurally correct, okay? But recall, for the purposes of today, it's important just to be aware that that is a method to get off of the board. The third one, if a board member is more than 90 days past due in any monetary obligation, they're off. They've abandoned that seat, okay? It doesn't need to be voted on by the board. It's an automatic thing, more than 90 days. The fourth one is going back to that slide we just talked about, but if there's pending criminal charges, you're actually off immediately until those charges get resolved. Also, the state of Florida, via the Division of Florida Condominiums, they can order removal of a board member. Relatively rare, but it can be done. Also, if you don't get certified, right, you don't get your required education done, you're suspended from the board, but you're put right back on as soon as you cure that certification requirement. All right. And the seventh way, it's kind of obvious, but when you have a new election, if you don't run for the board again, or if you do run and you're not elected, obviously you're off of the board. This is a very straightforward question, which not always a straightforward answer, which is board meetings are open to owners to attend and notice must be provided. Except for a few exceptions I'll talk about, notice of a board meeting just needs to be posted 48 hours in advance. A quorum of the board needs to be present for a board meeting to be held. Quorum is just, again, a fancy word. It's the minimum number of board members that must be at the board meeting. For quorum purposes, a board member can appear via, speakerphone or FaceTime or Skype. That's fine. Almost always, a quorum for a board meeting is a majority of the board, right? So if you have a 5-person board, you need 3 actually there. So if, let's say you have a 5-person board, obviously less than a quorum can always meet, do whatever they want, chat about whatever they want. The issue is when you have a quorum of the board, right? So let's take a 5-person board. The issue is when you have 3 board members gathering. Is that a meeting where notice needs to be posted 48 hours in advance? There's really 2 interpretations. There's a more, I'll call it a more conservative approach, which is the safer one. And there's, let's call it a less conservative approach. I don't want to quite say aggressive, but it's a less conservative approach of when a meeting is being held or not. Okay. The less conservative approach, I think, often is more common sense. Let's say, again, 5-person board, 3 board members are a quorum. Let's say you have 2 board members hanging at the swimming pool. Okay. Let's say a 3rd board member comes to the pool, just walks to the other 2 board members and just mentions something related to the condo, something as innocuous as, yeah, when is that sprinkler head supposed to be fixed? Now, you have 3 members of the board physically in the same space. One of them mentions something condo related. Is that a board meeting that you need to notice 48 hours prior and owners get to show up? My opinion is that's a very conservative interpretation, right? And I don't go that far. to support my view, the statute states that board members can email each other. You just can't vote via email. So if board members can email each other, probably makes sense they can speak on the phone to each other. And if they can speak on the phone, it probably makes sense that they can physically be in the same area at the same time without automatically it converting into a legal meeting where notice needs to be put up 48 hours. My personal view is that board members know when they're gathering behind closed doors, basically deciding things, and then at the board meeting, they're just rubber stamping what they already decided. That is improper, right? And that certainly, in my view, violates the intent of what the statute states. So you certainly should not be gathering behind closed doors saying, well, we're not voting, but you're basically choosing how you want something to be and then just rubber stamping it. There should be meaningful discussion, good faith, meaningful discussion at a board meeting where the owners are there and owners get to speak on agenda items. All right. So I'd just like to take a minute to go over that. Again, there's some recent changes to the law. You all know, hopefully, that at least 4 times each year, a board meeting must have an agenda item where owners can ask questions. Also, boards must meet at least once each quarter. That's a new change. Like I said, almost all board meetings, you need to have notice posted just 48 hours. The exceptions are where you have a special assessment. If a special assessment will be considered by the board, you need to mail and post notice 14 days prior. Again, you can exclusively email the notice only if you have the owners sign consent. And if it's a special assessment, if that's one of the agenda items, that agenda must state what the approximate cost of the special assessment is and what the reason for the special assessment is as well. The other exception, a board meeting, you need to mail and post notice 14 days prior if the board will be considering adopting rules regarding the use of the units specifically, not common element rules, but rules regarding the individual units. If the board will be adopting rule changes regarding those individual units, you need to mail and post 14 days prior. Again, same thing with meeting of the owners, meetings of the board. For those condos that have 150 or more units, you need a website, right? And you need to post copies of whatever the notice of the board meeting needs to be on that website for the same amount of time that you're required to, post it. So if it's a regular, 40-hour board meeting, make sure that notice is on the website 48 hours in advance. Okay. Every notice must have an agenda. Okay. The board under the statute can only vote on what is on the agenda. Okay. The only time you could vote on something that's not on the posted agenda is if it's an emergency and a majority plus one of the board members approves taking up that item on an emergency. Okay. So it's technically not proper if it's not on the agenda for the board to be adding things to formally approve. Okay. It really should be listed on that agenda. Under the statute, it's rare, but it's worth mentioning. If 20% of the owners petition the board to add something to the agenda, the board's required to do so. Now, it doesn't require the board to vote on it. It just requires them to add it to the agenda. And this slide here goes through that. All right. So if you're a manager or you're on the board and you have any questions, especially any board meeting where you're adopting a special assessment, it's probably best to run the notice by your association counsel before it's mailed and posted 14 days prior. Because if a special assessment, if the notice isn't done properly, our firm can't collect that special assessment from owners that don't pay on time. All right. So you're going to be forced to redo it. So it's probably worth it to have it done right the first time before it's mailed and posted. As I mentioned, board meetings where, the business of the association is being conducted, you're voting on things. Those are open to unit owners. Okay. Owners get to speak on agenda items. They get to record the board meeting the same way they can record a meeting of the unit owners. What I want to highlight on this slide is under the statute, and this is in 718, the only two fact patterns where a board meeting can be closed to owners is if the meeting is with the association's attorney to chat about, pending litigation or to get legal advice on something. Okay. Obviously, for attorney-client privilege reasons, that board meeting can be closed to owners, and it should be. The other exception that allows a board meeting to be closed if you're discussing personnel matters, right? Common fact patterns, whether the board is voting on whether to, fire one of the association employees. Okay. That's the type of board meeting that can be closed to owners. Under the statute, technically, you're supposed to post notice still 48 hours prior. It should say close board meeting. And the agenda, for example, should say close board meeting to discuss personnel. All right. So I just wanted to highlight those are the two times that board meetings can be closed. All right. Again, a member of the board, they can count for quorum. They can call in via speakerphone as long as those owners who are at the meeting can hear them. Okay. Voting by the board, it's not a secret vote. Okay. The only time a board member can vote via secret ballot is when the officers are elected at the organizational meeting of the board, which often follows the election. Okay, so the only time a board can vote via secret ballot is when they're voting to appoint the officers, right? President, vice president, treasurer. Other than that, it's an out loud vote. And, the minutes of the board meeting should reflect the motions that are made, okay, and by whom and how the vote was. Real quick on minutes of board meetings, they're not a transcript of what happened. I mean, I've seen some minutes of board meetings that are, pages and pages, and it really should just be the time the meeting's called to order, who's there, what motions were made and by whom, the results of those, how the vote went, and the time the meeting is adjourned. That's really all the minutes should include. And we don't suggest, adding a lot of, this owner stood up and said they hate the landscaper. I mean, I've seen all sorts of things. That's really not something that needs to be in the minutes of the board meeting. Also, committee. Okay, if you have committees, we talked about the independent, whether you want to call it a grievance or a fining committee. If the committee can take final action on behalf of the board, or it's a committee to deal with the annual budget, those committee meetings are open to owners, right? A notice needs to be provided, right? Owners get to show up. Other committee meetings can be exempted from the notice requirements if the bylaws exempt them. So that's something that's documents specific, whether your bylaws exempt other committee meetings. All right, two other brief topics, then we'll open it up to questions. I appreciate, again, I know 4 hours is a long time. There's a lot of stuff here, but we're at the tail end here. Insurance. This is a statutory item, right? What's required to be insured? It's in Chapter 718, okay? And a board is required to use its best efforts to obtain adequate insurance. I'm going to go back to this slide in a second, okay? What the statute says, and we're talking about often, the most common phrase is property insurance, right? The statute says the association is required to have property insurance for the entire condo, except for certain things, okay? And that except for is in this slide here, where it says the association's coverage must exclude, and then it lists several things. Those exclusions are really interior unit items, which are the obligation of who? Of the individual owner, okay? So the individual owner is required to insure basically the interior, and it lists those things here, and the association insures everything else. If there is damage from an insurable casualty event, right? An unforeseen thing, God forbid, a hurricane, a fire, okay? And there's damage. The question of who repairs the damaged property is simply answered by whoever insures that item is the person responsible for repairing it, okay? So if the interior of the unit, the built-in cabinets are damaged from a fire, the owner is responsible for those insurance reconstruction costs. If the roof of the condo is damaged from a hurricane or a fire, since the association insures the roof, the association is responsible to pay for any reconstruction. So a good thought on this topic is whoever insures the item is the party responsible to restore the item when it's damaged from an insurable casualty event, okay? So that's property insurance or casualty insurance. That's required by 718, okay? Another insurance that I want to touch base on is fidelity bond coverage, all right? That's insurance for whoever controls the funds of the condominium, okay? You need to have fidelity bond insurance, okay? That's required under 718. Other types of insurance that's not required by statute, but we certainly recommend it, is directors and officers liability coverage, D&O. If you're not sure if you have it, you probably do, but if you're not sure, definitely get with your insurance agent. D&O coverage insures the members of the board and the officers for lawsuits alleging like mismanagement, things like that. You want to have, of course, D&O coverage, okay? Other types of insurance, while not specifically required by law, certainly flood insurance. Certainly, if you're in a flood zone, you got to have flood insurance. But even if you're not, you've seen crazy things with these recent storms and the storm surge and rising water. Certainly, it's a very good idea to get with your insurance agent to talk about flood insurance, okay? Going back to the property insurance, if there's a fire or a hurricane, and again, the rule of thumb is whoever insures it is responsible to pay for the repair costs following that insurable event. The exception, obviously, is if the source of the insurable event is the improper conduct of an owner, the association can look to that owner for reimbursement. The fact pattern I always use is a case our firm dealt with where an owner thought it was a good idea to use the fire sprinkler in his unit to hang his clothes. Hopefully we can all agree that's an unreasonable thing. That's improper. The weight of the hangers and the clothes broke the sprinkler pipe, massive water event. That's an insurable casualty event, right? It's not a slow water leak, right? It's a burst pipe. So there was insurance coverage there, but the association, since the source of the casualty event was the improper action of the owner, allows the association to seek reimbursement from that unit owner. Okay. All right. Last topic, save sort of a juicy one for the end here, and then we'll get to questions. But this is the conflict of interest. Okay. And there's lots of sort of misunderstandings that I've seen, and I want to sort of clarify this. The main thing to know is that a conflict of interest in a condominium board context is a term of art. It's set forth in chapter 718 of the Florida statutes. Okay. It's in 718.3027. Okay. What the statute says is a conflict of interest only arises when an association is entering into a contract or a transaction with a board member or a company that a board member or a relative of a board member has a financial interest in. Okay. So let me say that one more time. The conflict of interest analysis in a condo board member context only arises when the association is looking to enter into a contract or a transaction with a board member or a relative of a board member. Okay. That's where the conflict of interest analysis is triggered. And I'll give you the end of the story first. The law does not completely prohibit an association from entering into a contract with a member of a board. Let's say John Smith owns a landscaping company. The statute in 718 does not say it is illegal or prohibited for the association to hire John Smith's landscaping company. What the statute says is that there is a several steps that must be followed. Okay. And it's all in your outline here. But one of them is John Smith must disclose that conflict that he has at a meeting of the board. He must say, I'm John Smith. I own John Smith's landscape, company. And that disclosure, the minutes must show that that disclosure was made. And the notice of the board meeting where their board will be considering hiring John Smith's landscaping contract, that contract must be included with the notice and the agenda. And that subject board member, John Smith, he has to abstain from voting. He can't vote on his own contract, and he must actually leave the meeting room while this agenda item is being addressed. Okay. And it needs to be that contract with John Smith's landscaping company has to be approved by 2/3 of the board, not just a regular, it's 2/3. It's a super enhanced requirement for board approval. The terms of the contract need to be fair and reasonable. And at the next meeting of the owners, the existence of that contract must be disclosed to all unit owners. And the owners actually have the ability at that time to vote to void that. Okay. So it's not prohibited. Okay. There are several procedural disclosure steps that must be followed. I'm not suggesting I think it's a great idea for an association to enter into a contract with a company that's owned by a member of your board. I'm just clarifying that it's not on the face against what the Florida statutes say. And this slide goes through those exact disclosure requirements. All right. Okay. Also, for managers as well, there's the same, conflict of interest requirements. If the manager has an associated company they're involved with, and if the association will be hiring that associated company, there's certain disclosures that must be made as well. And we outline those here. All right. With that being said, let me take questions on those topics 3 and 4. We got a question about how involved should the management company be? Obviously, that relationship really is a board by board type of thing. It's important to know that the property manager and the property management company, they're just an authorized agent of the condominium governed by the board. And the management agreement itself should clearly outline what the obligations of both parties are. So there's not one rule of thumb. We got a question about elections and can a board delay elections? That's a very fact-specific question. Our opinion, an annual meeting should be held annually, right? Generally within 12 or 13 months of when the last one was. Got a question about trucks. Again, there was a law, but that's only for homeowner associations governed under Chapter 720. There's no language in Chapter 718 regarding trucks. We got a question, and I'm reading into it a little bit, about doing a project at the community where, let's say, the railings need to be completely replaced, and there's language referencing in the documents that you need a vote of owners to do that. But the reason that the railings need to be replaced is that the county code is requiring it, right? There might be a 40 or a 50-year recertification process, and the licensed engineer has confirmed that the railings need to be replaced. In our opinion, and there's case law in Florida, if the project is part of the necessary maintenance or repair or replacement of the condominium property, the board has the authority to go forward with that without an owner vote. Okay. The rationale is, let's say you go to the owners for them to approve it. They don't approve it. Are you supposed to just let the property fall into a further state of disrepair, or, not be in compliance with some, county code? Courts have held no, that wouldn't be a reasonable result. So the main takeaway is, and certainly get with your association attorney if you have questions, but if the item is a necessary maintenance item, the board likely has the authority to go forward. We got asked a question about the notice and agenda of a board meeting for a special assessment and for contracts to be signed. There's this really quirky language that was added in the statute just this year that says a copy of the actual contract needs to be included with the notice and agenda. We've been active, and there's legislation hopefully will be considered soon to clarify that that's a pretty absurd requirement to post the contract. Some of these construction AIA contracts are 100 pages long. It seems somewhat absurd that you would have to physically post a copy of that. However, as of right now, the statute does say if there's a board meeting where certainly if a special assessment's being adopted and a contract will be approved as well, that you do need to include a copy of that contract with the notice and the agenda. We got asked a question about owners meeting. How many do you need to establish quorum? That's a document specific thing. Okay. If your documents are silent, it's a majority of all owners, 50% plus one. Got asked about a board. When can a board conduct a closed board meeting? I thought I went over that only 2 times, when the attorney is present to discuss pending or proposed litigation or to give legal advice, or to discuss personnel matters, whether to perhaps dealing with employee matters. About the board meeting, the proposed annual budget, that's adopted by the board. That's a board vote. Okay. Now, if the owners are voting to waive or partially fund reserves, that's done at an owners meeting. Oftentimes they're held the same day, one right after the other, but the annual budget is adopted by the board. Okay, I'm getting very fact-specific questions. So again, I apologize if I don't get to your exact fact pattern. Regarding limited proxies, the owner, let's say you're voting on amending the bylaws. The owner, I'm John Smith, I sign how I want to vote. I date it and I sign it. I then can name in the blank space who the proxy holder is. All the proxy holder is someone who like walks the proxy down to the meeting, essentially, right? The proxy holder doesn't get to vote. Me as the owner, I can name anyone I want as the proxy holder. Most of the time, and you would have to read the proxy. I can't read the specific proxy, but most of the time, if it's left blank, the proxy holder will default to a member of the board. Okay. But again, if it's a limited proxy, me as the owner, I'm the one voting on that. We got a question about reserves and waiving reserves. The annual budget, the proposed annual budget that's sent to the owners, it should show them what their assessment amounts would be with fully funded reserves, or if they waived reserves. They should see what those amounts would be for 2025. All right. Again, I asked about what quorum is. It's document specific. I would have no way of knowing what your quorum is unless your documents were specifically reviewed. If your documents are silent, it's a majority of all owners. That's usually what I see. All right. Regarding a board member and there being pending criminal charges, if the charges are resolved in the favor of that board member, they're not permanently banned forever. They can certainly regain their seat. We got asked, is there a dollar amount that the board has the authority to spend without approval from the owners? There's no such thing in the Florida statutes, and that would be document specific. Many documents do have language regarding material alterations where it gives the board authority to do it without an owner vote, as long as that material alteration does not exceed a certain dollar amount. But again, that's document specific. That's not in the Florida statutes. I got asked about how do we know if a board member hasn't paid on time. The account statements of each owner, and this is perhaps not widely known, but the account statements of each owner, that's part of the official records that owners have the ability to request access to. So a board or a manager cannot say you don't get to see the account statements. You get to see each owner, whether they've paid on time or not. Okay. We got asked about voting via email. If you're on the board, the statute says no voting via email. So board members sometimes will stretch themselves in all sorts of contorted ways to say, we didn't vote via email. I submit to you, when you're voting via email, and the statute says don't, okay? Now, are there times when there's extenuating things and the board could perhaps ratify? Ratify is just a fancy word for approve after the fact. Is there certain times where extenuating facts emerge and the board can ratify something in a future duly noticed board meeting? Sure. but that certainly should not be regular practice of any condominium board. We got questions about hiring vendors or choosing contractors. That all should be approved at a duly noticed meeting of the board. Okay, owners get to see how the board members vote, and all contracts are part of the official records that are open for inspection. We had a question about fines. Let's say you went through the proper fining process and an owner actually paid. That's wonderful. Fines can be treated as just, for any bona fide operating expense. We had a very specific question about insuring carports. That's very fact specific, but certainly if it's part of the association's insurance obligation, then you should have insurance for that. We got asked specific questions about what the D&O policy covers. Every insurance policy has their own sort of quirks and their own exclusions. So if you're on the board, definitely get with your insurance agent and have him or her walk through exactly what type of mismanagement claims would be covered by that policy. We got asked a question about if a board member was recalled properly, they are not banned permanently from ever, throwing their name into the, hat again, So if a board member is recalled at the next election, if they want to submit a notice of intent to run 40 days prior, he or she certainly is entitled to that. Okay. Trying to answer some questions from some people. Oh, there's Jeff.
Hey, that was Jeff. Me. No, you keep going. I just wanted to get rid of the screen share so they could see your face.
Thank you. See my face. Yes.
I'm trying to answer as many of these questions as possible myself. So
yeah, look, we're obviously not going to get to every single question. We appreciate everyone staying with us for this long. I'm just kind of doing a quick thing here where, I'm getting a lot of questions is we think the board's not doing what they're supposed to be doing. What do we do?
Yeah.
I went over, you can run for the election, you can recall them. If they're truly violating the Florida statutes, you can file a complaint with the state of Florida or certainly engage your own independent attorney. Got a question about denying applications. That's outside the scope of what we have here today. I know Jeff's talked about it, but we have a very robust calendar of upcoming courses and all sorts of topics, and we encourage everyone to check that out. With that being said, before I turn it back over to Jeff, and certainly if Jonathan has any last words, it's 4 o'clock on the nose, not too bad for a 4-hour course. And we really do encourage you all to give us your feedback. We read every survey and we appreciate whatever constructive comments you have. We really take it to heart. Our goal is to hopefully offer the best courses in the state of Florida. And we genuinely thank you for taking your time and hope to see you all soon. Over to you, Jeff.
I appreciate you, Andrew. Great job as always. And I'll go over the evaluation one more time, but before I do that, and I'll do it more slowly, I promise. I did it quickly the first couple of times because we had a lot of stuff to go over. So before I do that, Jonathan, I do want to give you an opportunity to give some parting words. But before you do that, I want to thank you for asking us to participate with you today. We always enjoy working with you. And folks, if you're happy with your management company, great. Don't do anything. However, if you are shopping around, if you are looking for somebody potentially new down the road, give them a shot. Heard nothing but great things. Jonathan, some parting words for everybody before I go over the evaluation once again?
No, this was a really valuable course, and I think a lot of us have been waiting a long time for something like this to happen, just to clear up some of the challenges that we've had. As a management company, RealManage is very particular about following the statutes and providing advice that follow within guidelines of the documents and the statutes. And I think one of the things that we offer is great advice. We have some really solid managers that work for us. And we are the third largest now and still on the Inc. 5000 fastest growing companies in the country. And my management company was, we managed from South Beach to Orlando, and most of my team is still in place. And we've just got some great folks that if you ever need any help, we also have the premier software in the country. It's totally transparent. You get 24/7, real time. You get the information when you need it at your fingertips. So if you need help, don't hesitate to call us. Thank you.
Thank you, Jonathan. And you're welcome to hang out, Jonathan, while people hear me blab about the evaluation. But yeah, I know you have things to do. If you need to go, that's fine too.
I appreciate it. Thank you, guys.
Take care. Thanks for having us. So, folks,
No, thank you for having us.
likewise.